to its reproductive. Sorry. Yeah. So, I was saying a gendered analysis allows us to fully understand that violence that essentializes a population to its reproductive characteristics. That reproductive capacity and reproduction comes to adopt a certain significance in genocide because it's that capacity that perpetrators are threatened by or treat as a threat, and so it's that capacity that becomes the object of the violence. And so recognizing what reproduction and reproductive capacity come to symbolize during commissions of atrocities helps us to fully understand the perpetrator's intentions. It helps us in uncovering what's mentally going on there. I want to look back a bit. So since the 1990s, as feminists, as activists, lawyers, as judges before both the tribunals, fought hard to have rape and other forms of sexual violence recognized as constitutive acts of genocide. And since then, since Akayesu, we've moved forward in that direction to have different types of violence, different types of harms recognized, including reproductive violence. And as we're thinking of documenting reproductive violence, addressing reproductive harms, there is also a case to be made that genocidal intent can be concluded by looking at the type of violence that's been committed, including reproductive violence, and who it is targeted at. And I'm conscious that this line of argument can very validly invite some critiques of essentializing violence that women face in genocide to their reproductive capacity. But at the same time, I do think the reproductive lens is really helpful in fully uncovering the genocidal intent and highlighting the perpetrator's view of themselves, their violence, and their victims. That in this case, in the Rohingya case, looking at the way in which the forces are using sexual and gender-based violence to target the reproductive capacity of Rohingya women and girls of reproductive age can tell us something about their genocidal intent. And I'm just going to expand on that argument a little bit, for which I'll jump into the doctrine really quickly for a couple of minutes. So apologies to those who are already familiar with that argument. But under the Genocide Convention, Article 2, genocide would refer to situations or acts that are committed with an intent to destroy a group either in whole or in part. And I want to stick with two words there. I want to stick with destroy, and I want to stick with in part. So what do we mean destroy a group? How do we destroy a group? And for that, we have some helpful jurisprudence. For instance, the ICJ in the Croatia case said destruction can be physical destruction, physical extermination, mass killing, but destruction can also be biological destruction. And while lots been written on physical destruction, I want, for what I say next, for you to just stick with the fact that destruction can also be biological destruction. And so it can be an intent to biologically destroy a group in whole or in part. And in part has been interpreted to mean a substantial part. But how do we decide what part of a group is a substantial part of that group? And through jurisprudence, and the paper will have detailed citations for all of this, through jurisprudence, we have some indicative, not exhaustive ways of answering whether a part is substantial or not. We can look at numbers, we can look at prominence of that part, we can look at geography. And while lots of attention has been given to numbers, the numbers of people killed, maybe that's how violence against men most often shows up in conflict and atrocities, prominence in geography can be equally illustrative, and I want to stick with prominence. So how do we decide if a part of a group is a prominent part of that group? We can look at if that part is significant enough to have an impact on the group, or the impact that its disappearance will have on the rest of the group. And the ICTY, in a couple of cases, and the one I want to highlight is Karadich, said that eliminating the procreative capacities of a group bears directly on the whole group's ability to physically and biologically maintain itself. And so in that case, the tribunal had concluded that perpetrators would have known that killing of able-bodied Muslim men and separating the rest of the population would have severe procreative implications for the remaining group. Now, if we take this, apply it to the context of Rohingya women and girls, through a gender-competent lens, it's easy to see how Rohingya women and girls of reproductive age perform an important social function within that group. They sustain the group's regenerative capacity and so are a prominent, substantial part of that group. Therefore, while physical extermination, killing in large numbers, may show the intent to commit genocide, so can an intention to biologically destroy using attacks aimed at the regenerative capacity of even a part of that group, if that group plays a prominent role, which Rohingya women and girls of reproductive age do in ensuring the group's survival. And this argument becomes really easy to see when we focus on the violence that's being documented in the Myanmar context. So the fact-finding mission in Myanmar has documented that there's been systemic selection of women and girls from the Rohingya community of reproductive age for rape, for attacks on pregnant women, for mutilation, for injuries to reproductive organs, for physical branding of bodies. Rape and gang rape are often done in public, so as to create almost a spectacle out of it. And all of this violence has had severe implications for the reproductive capacity of the community. In some cases where this violence has led to gynecological or genital injuries, survivors are unable to conceive. Their physical capacity to reproduce has been destroyed. But even in cases where that capacity has remained, injuries to genitals, gynecological injuries have led to, and this has applied to both men and women, so torture, sexual violence, reproductive violence. Survivors have reported that sexual intercourse has become a painful experience for them, and that's also reduced their reproductive capacity. And then finally, we also have to understand the social reality in which this violence is playing out. So where the idea of honor is imposed on women and their bodies, suffering, sexual violence, reproductive violence, branding of bodies are often seen as devaluation. They're often seen as tainted. And married women, for instance, have reported that after their husbands found out that they were subjected to this violence by the forces, have refused to have sexual intercourse with them. Single women, on the other hand, have said that the stigma attached to being survivors have created problems or have prevented them from establishing partnerships allowing for procreation. So what essentially has this violence done? This violence, clearly aimed at the victim's reproductive capacity, has eradicated the possibility for these victims to continue old or form new intimate relationships, something that's essential for the community to continue. And therefore, it's quite clear that the Myanmar security forces' use of brutal and public sexual and gender-based violence against Rohingya women and girls of reproductive age, coupled with the scale at which this violence is taking place, leaves no doubt that it's specifically aimed at impacting their reproductive capacity as a group, that it's aimed at impacting the community's ability to regenerate itself, which shows the perpetrator's intent to biologically destroy this group. And while this understanding for us has developed in the context of the Rohingya community, we can see it applied to the way violence is unfolding in different parts of the world. We can see it when pregnant women are attacked. We can see it when maternity hospitals are bombed. And this focus on the significance that reproductive capacity attains in genocide, in mass atrocities, is not, I think, an extension of the intention requirement in the convention, but only a gendered understanding of what genocide is, the different ways in which the intention to destroy a people can manifest itself, especially when it doesn't look like mass killing. And I think finally, just quickly, if I have 30 seconds, because I have this room of experts with me, I do want to end by saying that in all the conversations that we're having, the ones we've had today, the ones we will have tomorrow, in all the work that we're pushing ourselves to do, we stand on shoulders of feminists who fought hard before us to end gendered violence and achieve peace. And so we must keep our eye on that goal as we move forward in wanting to have different forms of violence addressed, that all of this is towards the goal to end war and violence itself, and is towards achieving a feminist world that's rooted in lasting peace. Thank you.
Ashita, thank you so much. I think this is on. I think you touched, you not only gave us a great class and on what genocide and genocidal intent is, but also on how it can be present in when we see acts of reproductive violence in a specific context. I want to also highlight what you bring about the key of what we have already documented, no? What has already been documented of the kind of violence that survivors have endured, and how from that we can make that analysis, that legal analysis, and hopefully we can bring it forward for accountability purposes. And then on this note on documentation, I want to go now to Payal, who is joining us online. So Physicians for Human Rights has recently published a report documenting gruesome conflict-related sexual and reproductive violence in Ethiopia. Payal, could you please walk us through the report's main findings and also share your reflections regarding the process of documentation of reproductive violence as genocide, and also of this as a crucial step in accountability for these crimes? You have the floor.
Thank you so much. Can you hear me?
Yes, we can hear you.
Great, great. Well, first, I really want to say thank you to the organizers for inviting me here today. I'm really sad I can't be there with all of you in person, but it is such a pleasure and a privilege to join these conversations. As Lana said, I work with Physicians for Human Rights, where we use science, medicine, and the law to document mass atrocities and violations of human rights, as well as to gather evidence to support accountability and justice. And we've been working for over the past 5 years now to be undertaking medical legal documentation, specifically of reproductive violence, in several contexts globally, including in Syria, Bangladesh, and then more recently, Ethiopia. This work has examined several dimensions of reproductive violence that were touched on in the opening remarks, both the gendered impacts of attacks on health, as well as the physical violence intended to harm reproductive autonomy or targeting of individuals because of reproductive capacity that sometimes overlaps with other forms of gender-based violence, including sexual violence specifically. So our work on reproductive violence in Ethiopia began in 2021, where we've been working with partners including the Organization for Justice and Accountability in the Horn of Africa, as well as Health Professionals Network for Tigray, to support health professionals and human rights defenders in documenting violence using standardized forensic tools. The conflict in Tigray began in November 2020 between the government of Ethiopia and the Tigray People's Liberation Front, but also involved the Eritrean military forces who were called in to support Ethiopian armed forces and numerous ethno-regional militia groups, including from Amhara and Afar regions of Ethiopia. And we had done some earlier reports looking at medical records of survivors of sexual violence to understand patterns of perpetration. And that early work really indicated to us that there was more to do to delve into the issues specifically of reproductive violence, because we were seeing in medical records some analysis and information that indicated that there was potentially forced pregnancy, forced transmission of STIs, but there was actually more work to do to understand the linkage specifically to sexual violence and then to link to perpetrators and their intent. And one challenge I think we were grappling with this early work was how do we collect that evidence, especially in a context like Ethiopia and Tigray, particularly where access is so limited. And where we landed was this project that, that culminated in this report entitled "You Will Never Be Able to Give Birth: Conflict-Related Sexual and Reproductive Violence in Ethiopia," which we published with our partner OJA about 2 months ago. So we developed a fairly rigorous methodology that is a mixed method approach, looking at quantitative and qualitative data sources, including over 600 surveys of healthcare workers who provided care to survivors of sexual and reproductive violence who were presenting at health facilities. We also reviewed over 500 medical records, conducted 40 key informant interviews, and 4 focus group discussions with healthcare workers, humanitarian actors, and community leaders who were supporting survivors. The data was collected from Tigray, Amhara, and Afar from the period from the start of hostilities in November 2020 through the end of data collection ending in October 2024. And what we were aiming to do is to be able to triangulate the data around important themes relating to sexual and reproductive violence, but also what we were hearing around intent, with the idea of really trying to understand what was behind the sexual violence and reproductive violence that individuals were experiencing, and did it rise to the level of genocidal intent as one of the questions. So I wanted to just share some of the findings relating to Tigray, where the link to genocidal intent was particularly well established. And we found in Tigray that survivors experienced brutal and deliberate forms of conflict-related sexual and reproductive violence, which caused severe and permanent psychological and physical harm to survivors, their families, and their communities. Legally, the evidence that we found showed both war crimes as well as crimes against humanity, specifically targeting reproductive autonomy as well as sexual autonomy. And so really often that the overlap rather, between these two forms of bodily autonomy, but really sexual violence often perpetrated with the intent of also controlling reproductive autonomy. So on the basis of our investigative findings, we found both the war crimes, including violence to life and person, in particular cruel treatment and torture, but also crimes against humanity, including targeting of women and girls for the crime of forced pregnancy, enslavement through control of sexual and reproductive autonomy of women and girls of Tigrayan ethnicity, deprivation of physical liberty, torture, rape, forced pregnancy, enforced sterilization, and other forms of sexual violence of comparable gravity. And we call for further investigation into crimes against humanity of extermination and genocide. We found for the survivors that were presenting at health facilities, they had experienced vaginal, oral, and anal rape. They had often experienced multiple perpetrator rape, with 91% of surveyed healthcare workers reporting treating survivors who had experienced multiple perpetrator rape. Violence was often committed in front of family members and in public settings. It often involved young and adolescent girls, and it also often occurred alongside other forms of torture and killings. What was really important, though, in this analysis was also being able to show the intent behind these acts. We found that survivors were targeted specifically based on ethnicity, and information gathered on intention to commit sexual violence showed that there was really an intent to cause impaired fertility, forced pregnancy, and intentionally infect with STIs, including HIV. And this really gets at the fact that, to show genocidal intent around reproductive violence, we need to really delve into the idea of how perpetrators are trying to control reproductive capacity specifically. So this, we're combating this notion, especially when it's sexual violence leading to reproductive violence, that this is opportunistic, this is one-offs, but really to show a pattern, but also to show that the pattern of this included an intent to control reproduction. And then, when we're looking at genocide, right, at the different acts of genocide, if we are looking specifically at prevention of births within a group, we then need to also show this specific intent around preventing births within the group. What we found here was really clear expressions of intent. So we saw language from perpetrators that were reported to health workers, saying threats to destroy your ability to reproduce, to cleanse your womb of Tigrinya. A psychologist in Tigray shared a story of a girl whose arm was broken and she became paralyzed when perpetrators tried to remove a Norplant contraceptive insert in her upper arm, and then proceeded to engage in sexual violence. And they said to her that you will give birth from us, and the Tigray ethnicity will be wiped out eventually. We also saw a really brutal pattern of insertion of foreign objects into the vagina, both before, during, and after sexual violence, which caused severe and at times long-term injury to reproductive organs. This included stones, metal, nails, plastic bags, and even handwritten letters. These letters in particular often bore expressions of intent to harm reproductive capacity. One healthcare worker shared images of a note removed from the uterus of a 26-year-old survivor from Tigray. And the health worker said this is one of several notes that were recovered from survivors. And this note, when translated, read, "We, the children of Eritrea, are brave. This is what we do, and we will continue to do it. We will make sure the women of Tigray will not be able to bear children. We will get vengeance for 1990. We will continue to be on that path." So we really saw both this expression of intent, but also in the medical records, the evidence that intent was realized. We saw long-term health harm. We saw forced pregnancy and HIV transmission, with 90% of healthcare workers seeing at least a few patients with unwanted pregnancy from CRSV. And we also saw records of women being held in captivity by military actors, raped repeatedly, and then forced to remain in captivity until they gave birth. And we saw that in the medical records, 50% of patients who were tested for STIs were positive, and 17% for HIV. And we also saw perpetrators expressing specifically the intent to infect with STIs and HIV. So, this is about Tigray, but actually getting to the point that Ashita was just making, that if we don't start working towards reconciliation, accountability, ending impunity, we also see these patterns replicating. And so I will say there's a whole part of our report that talks about how this is leading to more sexual and reproductive violence in Amhara, where now there is an expression of intent for revenge from Tigrayan forces in Amhara, specifically because of this lack of meaningful transitional justice, the shutting down of accountability pathways at the UN, at the African Union. And so this is really an important lesson learned from this work as well, that, we're seeing now 41% of healthcare workers in Amhara sharing that they're seeing sexual violence occurring, with an expressed intent for revenge. And that should really tell us all we need to know about how important it is for accountability and justice to be considered in breaking these cycles of violence. So just on your final point, very quickly to say, what we saw here is the importance of health sector data as well as multi-sectoral collaboration to be able to ensure that we are documenting reproductive violence in a way that is not re-traumatizing, is building on informed consent at every stage, and is really not leading to further harm or risk of retribution to individual survivors. We used health worker data in part because this allowed for more anonymous interviewing and anonymous reporting of evidence. It didn't require survivors to go through an additional process. These were survivors who were seeking care already, had already gone for care. And then it also, we had trained the health workers and we're working with health workers that were using standardized forms that included tiered informed consent models. And so this is another, way we often talk about the international principles around documentation of sexual violence, but those principles apply as well on reproductive violence. And so we've been developing these tools specifically with the idea of building on those lessons learned, ensuring the same principles of survivor-centeredness apply. We also have noted that there are intersectional gaps, right, in this analysis. We still see a lot of the data on women and girls because that's who comes forward to the health facilities. I think there are still gaps for men and boys in being able to report, and that's something that we are continuing to see how we can investigate. We're also seeing specific gaps around LGBTQI populations, especially where sexual relations between same-sex groups are particularly stigmatized or even criminalized. There are real barriers to accessing that data, and so that's something that we're also following up on. But I'll pause here.
Payal, many thanks for walking us through the horrific findings of the report, but also the comprehensive methodology you put forward to actually be able to gather all of this information and the analysis on intent. That is very, very key. I want now to turn to the audience for any questions and comments. Maybe we can gather some and then we'll interact with the speakers. So here we have a question.
Thank you. Thank you very much for the amazing panelist. That was really educating for me. My name is Kifaya and I work for the Women's Center for Legal Aid and Counseling. We're a feminist organization based in Palestine, and we have been documenting reproductive violence as a mean of genocide in Palestine for the past 2 years following the genocide. And we have so much things in common with all the interventions, and it's amazing to see the kind of ways some perpetrators find ways to harm women and their reproductive abilities. But when we're talking about Gaza, and maybe I'd just like to have a little comment on that, it's the kind of things we documented was the complete destruction of maternity wards within the first 5 months of the genocide, complete destruction of IVF clinics and fertility clinics. Even the doctors that worked on maternity, the OBGYNs were targeted along with their families. One of the things we worked on also with the complete destruction of incubators, the complete banning of any kind of facilities or equipment to be important into Gaza following the complete destruction of maternity wards, including the incubators, baby formula, and all the things related to maternity. So prenatal and postnatal care for women were completely banned. One of the things we documented is the 300% increase, which we have interviewed many OBGYNs in Gaza, and they told us that they would have over 10 miscarriages per day for women who couldn't even carry to term because of the famine that was declared in Gaza recently. And because of the famine, it resulted in so many women not being able to carry to term. And even if they carried to term, they would have a high rate of disabilities and high rate of, I don't know the word in English, but it's the disfiguration of the babies that they have had. In detention centers, Israeli detention centers, we have documented the targeting of women and their reproductive organs. They would beat them on their genitals. And this was not just in Gaza, it was also in the West Bank and East Jerusalem as well. This is in addition to men being raped and being beaten on their genitals as well. Sexual violence was really prominent in detention centers as well, including rape, insertion of objects in the genitalia was really common as well. And I encourage you to take a look at the Commissions of Inquiry latest report on the matter that declared it a genocide, but I also encourage you to look at their previous report in March. It was called More Than a Human Can Bear, and we fed into the testimonies and documentation, but it highlights it with such articulate manner in which you can see more how reproductive and sexual violence were committed with intent to destroy in whole or in part the Palestinian people. Thank you.
I see no other comments. Online, no, I see. Online? Yes. Do you have a question? No. No one else? Yes, Jeff. Jeff?
Sorry, the air conditioning doesn't seem to be working here as well, but that's just an organizational point. We'll see if we can have it working by tomorrow. Thank you so much to this extremely important, impactful panel. I have, first of all, a legal point, which is I suppose you're referring to 2D, basically the Genocide Convention, which is intention to prevent births within the population. I think that's, in terms of legal advocacy, we really need to sort of focus on that. And I think that these examples, the detailed examples that our colleague looking at the atrocities committed against Tigrayan women show is that the ways in which these atrocities take place really do require quite some level of uncomfortable detail. So I really, again, just want to honor you and the work that you are doing. Now, from a legal mobilization standpoint, just to really kind of ask the question, beyond recourse to the ICC and other institutions, there's a pending ICJ case on genocide. We hope that they will come up with a judgment soon. That would be very important and impactful. I don't know that South Africa addressed these particular aspects. I know they address some level of reproductive health, but certainly not this level of detail. Can the panelists suggest other tactics that we can be thinking about beyond the courts that we could take into consideration going forward? Again, thank you very much.
Thank you, Jeff. Ashita, do you want to maybe start and then if Payal wants to and Professor Wan?
Yeah, I don't think that's an easy question, so I'll try and then look to my co-panelists to help me out. But I think I think it's important to understand that courts also sit as sites of power. And so they are there is a likelihood of them replicating those structures of power that we're reaching out to them to fight. And so there has to be a certain, I think, for us, managing of our expectations and using courts as tools of emancipation. But I think they're helpful tools, and they do give us opportunities for us to expand the envelope. But I think I want to go back to something that Sarita said in the morning, right? That and she said this in an example of how the right wing has used the local pockets and worked, and now we can see how powerful that is. And I think while there is value in international law, the international law vocabulary, as well as institutions, we need to supplement that, and maybe this time the solution to international problems lies in local mobilization. So for us to also look at these local pockets, and yes, we should keep pushing the envelope. The international law vocabulary, the human rights vocabulary continues to have purchase. So that's not a site we can give up. but I think equally investing in those local sites in a sustained manner, which ties to the complexities of funding, and that is a whole other conversation, but investing in those local sites in a sustained manner to find solutions to global problems, I think, is a parallel strategy.
Thank you, Ashita. Payal, do you want to maybe give some reflections? And then we have a question from a participant online that I will read.
Sure. First to say, I don't think we should be limiting ourselves to 2D when we're talking about genocide and gender. So I think on reproductive violence in particular, it can constitute and be part of the pattern of other acts under the Genocide Convention that are prohibited. And so we shouldn't just look at prevention of births. Actually, prevention of births is a little bit of a narrow lens. And if you look, for example, at the example of Palestine, right, that was just shared, to show intent to prevent births when all of the hospital facilities are being attacked is possible. It is, and the COI report did it. But I think it's also important to be able to situate those attacks within broader attacks on killing of the group, and so I think it's not. I would not limit to 2D. I actually think it's important to understand that this is part of the conditions of life calculated to bring about a group's physical destruction. It's causing of serious bodily and mental harm as well, and so we should situate it within that broader analysis. The second piece is to say on tactics for justice and accountability beyond courts. First, I agree with Asha that we don't want to cede the space of courts. We do need to keep pushing, and there has been progress, especially on reproductive violence more generally. I think on genocide, there's obviously work to be done. But I think that that beyond that, we also can be looking at domestic processes. One of the biggest issues in Ethiopia is that the international community has ceded the space for international independent monitoring and documentation and justice to the national authorities, essentially deferring to a transitional justice process. In theory, there's nothing wrong with that, right? A transitional justice process can deliver meaningful accountability and reparations, but that's not what's happening. It's just not what's happening on the ground, and there needs to be proper oversight of that process, and then a stepping back in where it's clearly failing, which is what our report is showing. Beyond this, there are reparations schemes, right, more generally that need to be put in that don't require going through a legal process. And I know we heard earlier from Yazda, there's a lot of work that's being done to ensure that survivors don't need to go through a prosecution process to be able to access healthcare, to be able to access the other kind of financial and other kind of restorative forms of justice that they require and frankly deserve and have a right to. So I think that's another piece that obviously also plays out. And one of the saddest things we've also documented in Ethiopia is how the global aid cuts, and it's easy to blame just the US, but it's the US as well as so many other governments that are now funding money to defense spending or military spending instead of to health. They're really destroying systematically the ability of the health sector to be able to provide this kind of care to allow survivors, and often their children now, to survive, to push back at things like stigma, like Ashta has mentioned, which doesn't require a court to push back at. Actually, there's other ways to engage, and yet we're seeing this kind of move towards away from aid and away from global health support, which is really limiting the ability of health sector to be able to support as well.
Yes, please.
Again, not as a lawyer, but as somebody that's very aware of the importance of public space to know what is going on. I think what Jeff said is important, that often it's not heard, it's silenced, it's too difficult. And I think that is also another place where democracy, we can't give up on that either. And I think that's actually what these reports need to be out somewhere, not only in terms of a court system, but actually exactly in the civic space, which very concerned about these things and would be able to support through democratic means. Now, that sounds perhaps too vague, but that we've got to have that. Otherwise, we're ceding space all the time to right-wing groups who are all too happy to take that space up. So I would just add that as an important strategy as well. And I'm sure you're all aware of it, but that takes extra work. It means translating into sort of different kinds of language so people can hear it. without losing the importance of all the sort of expertise that's in this room, for example.
Thank you so much, Professor. We have a question from a colleague online. I will read it out. They ask how to balance the sexual and reproductive health of women and girls in a community facing genocide. We work with Rohingya women and girls for healthy birth spacing, prevention of early pregnancies, but in the face of genocide, what kind of issues should we consider? Do you want to?
I'll try it, I think. Can you read the question out for me again? Sorry.
How to balance the sexual and reproductive health of women and girls in a community that is facing genocide. This participant worked with Rohingya women and girls for healthy birth spacing, prevention of early pregnancies, but in the face of genocide, what are the issues that they should consider in terms of sexual and reproductive health and services and rights?
Yeah, I think and I say this with full recognition that it's challenging. I think centering needs is a lens that's often helpful. So the sexual and reproductive needs of women and girls, but also sexual and reproductive needs of the population more generally, if those needs are centered and services are responsive to those needs, I think is helpful, including for survivors. So when we look at, like Payal was mentioning, healthcare responses, for those to be more holistic, for those to understand more holistically the impact on survivors' forced pregnancies and what that can mean later on, including what that can mean in terms of severance of ties with the community. I think centering the needs of the survivors and the sexual and reproductive needs of the population is a helpful lens to decide what next. I think Payal wants to come in.
Yeah, I'm happy to jump in. So yeah, to say the same, yeah, exactly, Ashita. I think we need to be looking more comprehensively if possible. And so again, I think thinking about not just planning births, but also maternal health care as a whole, counseling around trauma and mental health impacts. I think, we really do see the impacts of reproductive decision-making that are also coming from being in a context of genocide or a context of conflict, and then the ways in which it can make pregnancy also more unsafe. So even caring for pregnant women in that context requires a different lens. Where sexual violence is leading to forced pregnancy, I think that's another set of issues that would be really important to address. And, we've been talking a little bit here, and especially in the context of Palestine, around intergenerational impacts and also not, thinking about the ways in which, for example, starvation can have epigenetic impacts that we need to look at more broadly. And so how do we think about who are survivors and who is impacted, whose care we need to be really bringing this lens to, this trauma-informed lens to. And so I think that's another piece that we talk quite a lot about, but I think there are tools for healthcare workers who are balancing this. And what we saw in our own documentation in Bangladesh is that often survivors of sexual violence were not coming forward to report sexual violence to the health sector. They were coming to the health sector because they needed care. And then in the course of an examination, in the course of asking for informed consent, it would come up that they were a survivor of sexual violence and that there was trauma. And then, there's a standardized form that PHR works with partners to implement, we train on, that allows for kind of a more systematic documentation of that violence in the situation where that's coming up. So it's not the case that it's often women and girls or even others coming to a health center to report sexual violence. They may not even be coming to a one-stop center. They're coming, because they have a health need, like a fistula that hasn't been addressed, something else. And so then we start probing from that point. And if they're comfortable, we do the documentation. If they're not, we stop. And so that's maybe that's another lens through which to think about some of this care and how to balance.
Thank you so much. We have one last question, and then we will close. Yes.
Sir, what hand was it? Thanks. Hi, my name is Lucy Hull. I'm assistant professor at the University of Amsterdam. one of the things that I was sort of linking across the cases presented here, Gaza, Ethiopia, and Myanmar, is also the question of the complicity of states like the Netherlands, like Australia, in providing parts of F-35 bombers that have been used to bomb maternity hospitals. And so also, you know, to go back to the question of what are the other legal avenues? And I know the case in the Netherlands, they haven't explicitly connected the delivery of F-35 parts to the bombing of maternity hospitals, but there is a clear link in my mind of how a legal process of holding the Dutch state accountable for its complicity in violence in Gaza is connected to these questions of reproductive health and reproductive violence. And I think there's also the broader aspect here of bringing this together as reproductive justice. And what does that mean going forward? Also thinking about the limits of the environment, climate change, and the environmental impact of, you know, Western domination and the pollution of environments that has also had an impact on the reproductive capacity. Yeah. Mic drop.
I think we'll have one final question and then we'll... Sorry. Yes, and then we'll come back to the panelists directly after.
Hi, thank you so much. I'll be really brief, but I think one thing that kind of listening to the presentations and grappling with this is how movement forward on this kind of emerging area doesn't contribute in any way outside of rooms of feminists to essentializing women and girls to their reproductive capacity. And so how do we think about this and also bring in the conversation that, you know, we don't think of men as having reproductive capacity. Ashita hinted towards the Karadzic precedent, which very clearly actually points towards the fact that men are holders of reproductive capacity in this sense. And so how do we go through this as we think about this as an emerging norm of making sure that it doesn't end up contributing towards an essentialization of women?
You want to offer final reflections? I will give the floor to the panelists. Ashita, please. We have now.
I'll just give a couple of, I think, closing thoughts. I think for the first comment, I think that's really helpful, and that's something I did want to hint at, that this, when we look at this work, while it is about, and it's important to document violence accurately and harms accurately for them to be addressed, including not just before courts and tribunals, but also reparations. But all of this work should, I think, happen with an understanding that atrocities don't just occur. They don't just happen in silos. There are structural factors that have contributed to it, often with deep-rooted links to colonialism and how we've functioned. And sometimes the institutions and power that we look for emancipation has historically contributed to these atrocities. And I think moving forward with that understanding can help not just single out the violence and knowing that is important, but also knowing to zoom out and situate that this is not, it's not just happening. And I think, Akira, what you said, I think is really important. I've myself been thinking about it, that I think what helps, and maybe this is a conversation to take outside of this room as well, is that women's experiences or a group's experience of genocide is nuanced. It is not essentialized to their reproductive capacity. But I think at the same time, looking at that from the lens of the perpetrators, that perpetrators are essentializing the population to their reproductive capacity, and that's what's motivating that violence to their reproductive capacity. And yes, it manifests in harms much beyond the reproductive consequences to them. So I think looking at what's causing that violence, but then looking at the harms in a more nuanced and more intersectional manner can help sort of balance that out. But I think that's a valid critique of this lens.
Do you want to offer some reflections?
Okay. Yeah, thank you. And then Pale at the end. Yeah. Thank you very much. I appreciate a lot bringing it out to the whole issue of reproductive justice as such, and also linking it to climate justice. But these are exactly really difficult issues to bring into, I think, public awareness. And we have to be careful how we do it, because then it starts to sound almost impossible and people will just not hear it. So I think that the nuances that actually this panel has very much shown, intersectional nuances, very aware of all the different actual geographical places, the context, the historical context of why these things have happened. I think that's the sort of work that has to be done. And I mean, I really think that the care with which this work is done is what is the most important thing, the listening. And I appreciate very much that includes the understanding the colonial legacies that we all carry, including the Dutch government, including the Australian government. But what I'm just sort of, we just need to be careful how we propose those sorts of arguments. To do it with the attention that's been given in this room, I think is one way, and then to broaden it out. I think how you answered that was really important. So thank you. And I would also say we're here meeting at in ISS, and I think that this is exactly the sort of work that, and probably also at the University of Amsterdam, I'm sure also, we try to get people to students to think these things through carefully, based on evidence, based on an understanding that this is many, many years of thinking through. It's not just a simple, this is how we do it. So again, thank you very much for raising that. But, you know, these are the sorts of conversations, as I said, need to be taken into the classrooms as well as into the public arenas. Thank you.
Thank you so much. Payal, you have the floor if you want to offer some final reflections. Thank you.
Thank you. No, these are really wonderful questions and really ones we're grappling with. I think on the question around how we avoid essentialization, I think there's twofold. I think the first is that it doesn't mean, right, that we shouldn't be documenting these impacts and violations of reproductive autonomy for women and girls, but I think we also need to recognize that it is affecting men and boys too. It is harder to document for a lot of reasons. I raised some of them. You know, infertility in men, for example, is often due to untreated STIs, but getting data in a conflict zone on STIs with, you know, amongst men is not easy to get. And then to be able to make the link to, okay, now we don't have access to the treatment for STIs which will, you know, create the pathway to infertility. That's even more challenging to piece together, but it is certainly a set of inquiries that I think need to be undertaken. We often see from men, and that the analysis is around harm to genitals, right? So it'll be things like shooting, targeting, you know, male genitals or electrocution or things like that. And that's really where a lot of this is focused as well. But I think it is important that we're also addressing the documentation challenges that are leading to this to be seen as only an issue around women and girls. I think the second piece, though, is actually getting to the question that was asked earlier around outside of court sort of remedies, and that we need to, or maybe even within court, we need to be advocating for any sort of response to documentation of or evidence of these violations, to include addressing the gender norms that are feeding into this type of kind of pattern of violations. And so just like we talk about with sexual violence, we also here need to talk about it with reproductive violence, that part of systemic remedies actually need to include that kind of norm change. And we're not going to get to a situation where forced pregnancy isn't occurring if we're not actually addressing the stigma, for example, that comes for women giving birth outside of a group. And so I think that's another area, but it is certainly an ongoing, you know, I think challenge and concern. And I think it's going to be important for us to continue to grapple with that as we go forward. So yeah, I mean, I think the other piece is that I think we also still are really seeing that there is a tolerance for this kind of violation occurring. On one hand, it makes headlines, right? Our report, you know, was published alongside this big Guardian piece, and every diplomat I talked to had, you know, seen the Guardian pictures of X-rays of women's uteruses and, you know, really ready to be up in arms. But when you actually said, okay, so are you willing to support, you know, pushing for a Human Rights Council investigation to open back up on this? No. Right, that they're still not willing. And so, I mean, I think that continues to be a challenge we're grappling with, which is that people are outraged. They're their male, that kind of, we must protect women sort of narrative comes up, but it does not translate to any sort of action, which is, which I think is something I'm really grappling with the context of Ethiopia is what do we do from this point? We have this really brutal evidence, and yet I think there's a real tolerance for impunity.
Thank you so much. Thank you so much, everyone. I think our time is up for today. This was an urgent and I think the conversation, and I think there's a lot of momentum to keep also having around the challenges for accountability before international justice institutions, but also what is happening domestically, and then the challenges that are very, this stark reality that Payal is sharing with us. I want to thank very much the panelists for walking us through. I think it was a very powerful way to end the first day of this conference. I really thank you all for powering through until the end. It's almost 6 p.m. Thank you so much. We hope to see you tomorrow. And with that, we can close. Thank you.
There we go. So there we go. Thank you very much. And good afternoon, I think we are at already. Thank you very much for joining us for this next session that I'm very excited about. As you may know, my name is Alix Villemain. I'm the Executive Director of Women's Initiatives for Gender Justice, and the great honor to co-host this conference and to co-host this panel as well. We have had already such very rich discussions over the last day and a half, where we explored so many fundamental themes that I am very keen to bring into the discussion with regards to repairing gender-based violence, but also, and I'll ask our panelists to reflect on that as well, how do we make sure that reparations, when and if we try to explore those options in the context of international criminal law, can be gender sensitive, if not gender transformative? What measures, what avenues do we have in order to do so? I'll keep it quite brief because we started a little bit late, but I'm still very keen to finish at 1 so that we can all go and enjoy our Dutch sandwiches and network with one another. So before I do, once again, as my colleagues have indicated, these are not the most easy topics at all. So please do take good care of yourself. If you need to step out, don't worry, please do. And please go find our well-being spaces in this building that are organized for your well-being. So without further ado, I'll turn now to our panelists. And I'm very, very proud to have such a fantastic panel with us today. So first we have Christina Kitt, who is a Ukrainian lawyer and the chair of YourFem, a feminist organization, joining us from Lviv. Thank you very much for making the journey once again to share your wisdom with us. And then we have Deborah Ruiz-Rodusco, who is the executive director of the Trust Fund for Victims Secretariat within the architecture of the International Criminal Court. And then we have Kolbasia Hausu. Thank you very much for joining us as well, survivor activist and the lead of Survivors Speak Out. And then we have online Jackie Mutera. Well, I look at you, but then I turn away from you, I realize as well. The founder and executive director from Grace Agenda, joining us from Kenya. Thank you very much for being with us. Christina, may I start with you, please? Great, thank you. Some particular questions that I'm keen to explore with you as well, but I'll let you address from your experience, is some of the key concerns that I think brings us together here is the backlash against gender progress, and that backlash and even progress in general operating from a situation of active conflict, as you have been doing in the last 2.5 years. How are reparations even a reality for you? Thank you.
Thank you. Thank you Alex, dear colleagues, dear partner, dear friends. My name is Christina Kitt, and I am a lawyer. And since 2007, I work with survivors of gender-based violence. And since 2017, I started to unite female lawyers and legal community in general around gender-based violence issues and gender discrimination. And of course, together with my colleagues, lawyers, human rights defenders, we try to respond on war crimes, including conflict-related sexual violence committed by Russian in Ukraine, and in this work we implement on the different level, on the national level, when we work with our legislation and propose amendment to our legislation. Also, we strengthen capacity of our state authorities who provide services for survivors of gender-based violence, including conflict-related sexual violence. And of course, we provide legal aid as lawyers for survivors of sexual violence, including conflict-related sexual violence. And what we have now, if you talk about how work civil society organization in Ukraine, especially women's rights organization. First of all, I want to say that women's rights movement in Ukraine always was very active, especially during the war since 2014, when Russia started the war, this war, and women's rights organization continued their work in 2022 when Russia started full-scale invasion in Ukraine. And if we talk about what do civil society organizations, especially women's rights organizations in Ukraine, who advocate gender issues, who propose any recommendation and amendments on the national level and on the local level. Only one example I want to share with you. In 2022, when Russia started full-scale invasion in Ukraine, women's rights organization, together with our government, with our gender government commissioner, updated our National Action Plan City 25. And we include in our National Action Plan all measures connect with war crimes, challenges. Also, we include measure connect with involve women in decision-making process. And it's very important for us that we can be, as a civil society organization, involved in all process connected with create policies and respond on war crimes in Ukraine. Additional to this, very important, if you talk about reparation for survivors of conflict-related sexual violence, in 2022, together with our member of parliament, with our law enforcement system and civil society organization, including organization established by survivors of CRSV. Now in Ukraine we have 6 or 7 civil society organizations established by survivors of CRSV, 2 established by female survivors, and 4 established by male survivors of CRSV and torture. And together with this organization, we worked on a draft law about urgent interim reparation for survivors of conflict-related sexual violence. And as a result of this work, in 2024, last year in November, our parliament adopted this draft law about urgent interim reparation for survivors of conflict-related sexual violence. And now our big task and our big challenge, if I talk about our, it means civil society organization, government and international organization, it's work on implementing on this law. Of course, we have some draft of implementations documents now, and we are waiting when our Minister of Social Policy will adopt these implementation documents, and we will continue to provide reparation mechanism for survivors of conflict-related sexual violence. It does not mean that now in Ukraine we don't support survivors of CRC, and it does not mean that we don't have any services for them. Of course, we have the services, and together with, for example, Global Survivors Fund, Mukwege Foundation, we provide reparation for these survivors. Our social system try provide different services, but very important for us build this governmental mechanism, how government have to respond on CRSV, and especially how government can provide complex services for survivors of conflict-related sexual violence. It's our main and big task. But when we talk about reparation for survivors of CRSV, one type of reparation mechanism is justice too, and responsibility for all perpetrators. And of course, on domestic level, we investigate all of these cases. Now in Ukraine, registered more near the 200,000 war crime cases. It's very big number of war crime cases. If you talk about conflict-related sexual violence, officially we have our prosecutor office registered near 500 cases committed by Russian soldiers. Of course, we understand that it's only official number, but not all of survivors now already talk about and report about conflict-related sexual violence. At the same time, when we communicate with other survivors who received legal aid from us, it's 84 survivors now work with our organization. When we ask them what is justice for them, they talk not only about verdict on the national level. For them, it's clear that we will have verdict on the national level. Now we have near 8 verdicts if you talk about CRSV cases. But for them, very important justice on the international level. And if you talk about justice on the international level, of course, it's our task as an international community, lawyer community, understand that all perpetrators, especially high-level perpetrators, all commanders, politician, Russian leaders, have to held accountable for all these atrocities. If these people will not held accountable of all these atrocities, we cannot talk about justice. We cannot talk that these atrocities will never be again. Yes, and it's very important to understand that, especially now, if we have many discussion around peace building process, etc., we have to remember about human rights and responsibility for perpetrators, Russian soldiers, Russian commanders who committed all these crimes against humanity and crimes of aggression in Ukraine. At the same time, if you talk about justice, it's not only a work of justice system, it's a work of all agency who provide humanitarian aid for survivors of conflict-related sexual violence, who provide any services for survivors of CRSV, and we have to implement a survivor-centered approach in this process. What does mean survivor-centered approach? Of course, all of us know what is this, but for people, it's understand that they are subject in this process, but not instrument in our hands. We have to understand and have to clearly know how to identify needs of these people, how we can respond on all of these needs, how we can be honest with these people and talk very open with them. On the national level, of course, our organization, we now implement and work with our law enforcement system and justice system, and we step by step implement survivor-centered approach during investigation process, in trial. Of course, we at the same time we try build this referral mechanism, because we understand as a lawyer and our prosecutor understand that if survivors of CRSV will not receive any psychological support, economical support, if they not feel that they are in the safety, they will not really report about any cases. It's clear for us, yes. And now we as a lawyer have to think how we can work together with other agencies who provide different services for survivors of conflict-related sexual violence, but not only for them, but for all survivors of gender-based violence, because it's not work when we will have very best and good system respond on war crime cases in CRSV. But if we will not have good system, domestic system, who will respond on all gender-based violence cases, we will not have any results. It's this two processes have worked parallel, and we have to advocate survivor-centered approach in all justice system, in all gender-based violence cases, not only in war crime cases. And if we want to have results in this area, we have to work together with all stakeholders, of course, with governmental stakeholders, international organizations, civil society organization, and together we can achieve good results in the future, because now we see that step by step we have not bad results on the national level, and we have not bad results on the international level. First of all, we know about register of damages for survivors of war crimes in Ukraine. Of course, very sad that that only survivors who suffered from 2022 have rights applied to register of damages. It's very big task for us as an international community. Remember about survivors who suffered from war crime cases since 2014, because it's some discrimination against survivors of war crimes if one of them have rights on compensation, but other of them don't have rights on this compensation. It's two very big question and important question. And of course we have special tribunal about aggression against Ukraine. It's a very big result of work of our government and international community. It means that we have to continue this work and remember about gender component during all process, and remember about all survivors of conflict-related sexual violence since 2014. Thank you.
Thank you so very much. Thank you. Thank you so very much, Christina, for laying out all the different facets and components to try to work indeed together with all of these international organizations, national organizations, national elements as well of the government, to try to be survivor-centered, to try to be feminist as well, to have gender competency, if not transformation as well through that. So I could ask you a few more questions about that, but unfortunately, again, we are a little bit short on time. But again, colleagues, as always, please do see these panels to identify our experts in this field on these topics. Please do connect with them, connect with us, so that we can have these discussions and continue these discussions and knowledge exchange far beyond the half hour that is still left to us. So thank you again. Let me now turn to you, Jackie. Yes, thank you. Let me now turn to you. I have two very simple questions for you, which I'm sure you'll be able to answer in under 5 minutes. First, in your experience, and thank you again, joining us from Kenya, Jackie was supposed to be with us. Unfortunately, visa issues have made that impossible, but we're very happy to have you here. So joining us from Kenya and your experience there, can gender-based violence be repaired? How do you see that? And since at this conference, we're really aiming to have practical tools or ideas, what are some of these practicalities that you see perhaps our community of ICL practitioners do or fail to do that you would like to share with us so that we can learn from your wisdom? Over to you, Jackie. Thank you.
Thank you so much. And colleagues, it's a pleasure to be with you. And I'm so sad that I'm not there. But at the same time, I'm so happy that I'm online, because I really feel a bit of emotion because of the subject matter. I've had the opportunity to listen in to the sessions from yesterday. And I've been so impressed and so touched by the actual practical applications and presentations of colleagues who have made the presentations, because I thought it was going to be just an exercise in academia. But I really am so grateful to be part of this, and I'm truly honored to be part of this. And I'm wondering to myself, and as you've asked me, Alex, how do you repair moments of torture from sexual violations and 17 years of toil for justice? How do you frame it? And even as I begin, I want to honor all the survivors that I'm speaking for and I'm representing, because I know many of them cannot come to such platforms. But I appreciate that you're willing to listen to our experiences and to share them and to utilize them as lessons learned. So thank you so much for the inclusion. I'm somehow grateful that I'm here. It has triggered so many memories and emotions, especially as very recently I was with some survivors, as recently as this past weekend, and they're crying about being neglected. And many of them were men who had been violated and had been castrated, and they had been forcefully circumcised. because of the violations. And they were asking me, well, who will remember us? Who will think of us? And as you're asking me about repair, I didn't have any answers for them. But in survivor-centered, utilizing survivor-centered approaches, they themselves have a sense in which they feel they can be compensated, not fully repaired. Repair also speaks about something that has been torn and you're trying to stitch it back again or trying to seal it again. If it's wood, trying to glue it back together again, but it can never really be the same as it was before, and hence the repair. But for survivors and in dealing with many of them over a period of time, I've come to know that one of the most important things to them is official public acknowledgement. If they are acknowledged that they are survivors and that there was harm suffered during a period when all they did was just to go and partake of their civic duty, if they're acknowledged that gangsters came upon them, if they're acknowledged that state agents fell upon them and raped them and beat them and subdued them, that the acknowledgement is one of the key things in repairing them. It repairs their morale, it repairs their sense of loyalty, it repairs their sense of nationhood, and their sense of belonging to a people. That is one of the key things that comes when it comes to repairing them. And secondly, it could be part of it is also awarding financial compensation. And others mentioned, please forgive me for being so emotional. It's because I'm so grateful to be in such a space where practitioners actually acknowledge survivors and the interventions that they do, and it touches my heart. And so thank you for that. And so part of it is also the awarding the financial compensation, which is part of the raft of reparation measures that can be included in them. But also is the institutional reforms that create and cultivate a different culture. I remember during the time when Kenya was going through the transitional justice process, we participated in the police reforms, and we were trying to transform it from a force to a service. A lot of they didn't really understand what it was, all the hullabaloo was all about. About the viciousness and the brutality in which they dealt with many of the survivors and many of the women who were beaten and were raped. But over a period of time, that culture and our participation in it, many of the survivors who participated in it have made them more sensitive to human rights, have made them acknowledge the pain more, and it even made there was a change in the past two general elections because a lot of it came from election-related sexual violence. There was a change. There was literally a visible change of the numbers that were experienced from 2007 to 2013 to 2017 and now to 2022. There was a visible reduction of them simply because of the institutional reform. So that was one of the ways in which you're able to repair, because now survivors feel that this is no longer a force, but it is a service that is there to protect humankind. And then there's also the putting in place symbolic measures such as memorialization. I don't know how many of you know about the petrified survivors, the statue, which is currently actually in The Hague, and I encourage you to go and look at it, in which we all participate in survivors from, I think, from more than 20 or more than 30 countries participated. And in it, we put our thoughts, we put our heart, we put our expressions of what we thought we wanted to be remembered, because there's never been a memorial that would recognize sexual violence. We do have Kim Bok-dong in Japan, and for the fight, what she fought for. But for the petrified survivors, really explains and expresses exactly what it was. So every nation that participated in the process was able to identify something. And Rebecca Hawkins, the sculptor, put every single item in there. I specifically requested for there to be a baby because of the children that were born from sexual violence. And she did put a baby on the sculpture. And all of it, and for that, I can always refer to it as a memorial. It might not be in my country, but it is somewhere in the city where human rights are respected and honored. And that's how it is. And then critically also, how repair can be done is by acknowledging the children that are born of rape as survivors, whether primary survivors or secondary survivors, but acknowledging the children that are born of rape as survivors. All of the above that I have mentioned means utilizing a survivor-centered approach. And my colleague before me utilized the words, and she used the words what survivor-centered approach to them is subjects in a process and not instruments in your hands. But we simplified that with the survivors when we thought about it. What does it really mean? And for us, it really meant the inclusion of survivors in any intervention, in any initiative, in anything to do with them, to ensure that they're there from the conception to the designing to the implementation of any such intervention, whatever it is, so long as they're part of the process, that by default, they will see the hurdles that are ahead, they will see the bottlenecks, they plan it out, they work with themselves and amongst themselves, nothing about them without them. They work within themselves and they know what is going to happen. And by default, that creates sustainability because they're part of the process and they feel an ownership. And therefore, by design, that becomes the monitoring implementation. So you've got an entire component of a project simply by utilizing survivor-centered approaches, by including them from conception to design to implementation. And this also means to listening to what resonates with survivors. And many times in interventions, I'm privileged also to be part of a process where I give insight into survivor-centered approaches in humanitarian settings. And usually the first thing that you think about is perhaps that getting them to a place of security, which is of course very important after conflict. But then thereafter, what happens to them? Do you listen to them, or do you think that they need food? Do you think that they need shoes? Do you think that they need pots and pans? Or what do they want to think? They are concerned about what has happened in their bodies. They are concerned about where their children are. They are concerned about what has happened to their children. That for me is a survivor. That means listening to what resonates with the survivor. That's a survivor-centered approach. In our study on reparations supported by the Global Survivors Fund, what came out clearly in the report, apart from everything else, was critically, in order of preference, dignity, then homes, then health cards, then education for those who had missed the opportunity to complete their schools, then education for the children who were born of sexual violence, and then there was compensation, and then their homes. In order of priority, it came exactly like that. So usually when people think that humanitarian interventions or the reparations should start from where academics think it should, at times it falls short simply because they have not consulted with things on the ground. And different reparation and different survivor organization and survivor settings will present differently. Within Kenya itself, with the survivors that I work with, the ones that were at the coast and who suffered the police brutality, the first thing that they think about is their health, their physical health, because they were battered, they were given vaginal batting, they were beaten with guns, they were beaten with batons, they were raped, they were beaten. Some of them lost their parents, and some of the children speak for their parents. In Nairobi here, it was rampant abuse. Some of them they think more about the compensation because they think it was an indignity and in service to them, simply because it was a tribal war, it was a tribal conflict at that time. And so that is very different also from those who are IDPs who experienced something different because they had to run from their farms, they had to take refuge in police stations, take refuge in churches, take refuge in public space, in stadiums, and then transported to places where they knew nothing, knew nobody, but had to start all over again. Their needs are very different. You must utilize a survivor-centered approach. And reparations means transformation. It has to be transformative. And it has to be co-created with survivors. Don't think that by giving them money, you are going to, in the name of livelihoods, and thinking that because of you've given them money, now they are going to prosper, now they should be okay, now they should get out of it. If a woman has been violated, one of the critical things and one of the starting points should be the mental and psychosocial support for any survivor. You cannot give money to somebody who is not healed mentally. They will spend it on anything. They will be unable even to account for that money. The money will be unable to be useful to them and useful to the society, and they'll spend it. And you'll have nothing to show for it simply because you did not start with what was critical to them. And then there was dignity for their husbands who were violated and their children who were with mental health issues, who witnessed the violations. That was critical for us for repairing. We're still talking about repair. I haven't spoken about anything else. And then the restorative surgery for the penile mutilation, for the dignity and the respect that the men need as they go into their homes, as they're known in their communities that they were castrated, that they were forcefully circumcised, and they no longer have penises and they no longer function sexually, and therefore they are considered half men. That means something. And for them, what they wanted, what are prosthesis, a prosthetic penis. If ever there was such a thing that could be done, they would want that so that their dignity can be restored. But how easy is it for you to get something like that? Even in Kenya, even in any other reparations program, any other redress program, it is a difficult thing. But those are things that you deal with when, and especially when you're bringing on male engagement and the aspect of male survivors, critical such subliminal issues that come out that people don't usually think about. People think about just about what the how the warring partners have to come to peace together, have to come to talk together, have to come to the table and agree that this is what's going to be done. There has to be a ceasefire for there to be a ceasefire. But the actual communities, the actual body count on the ground, the actual impact of it is felt by the survivors. And so immediately after the guns have gone silent, one of the recommendations for repair is for an initial support, after the initial support, to be at least a minimum 1 year care program. Why do I say 1 year? Because how will you know who is pregnant in the first month? How will you know who has got mental health issues in the first month? How will you know anybody who has got a medical condition in any? How will you know who is suicidal? And how would you know who has got any suicidal tendencies in the first month? You will know these things after staying with them in the first 6 months to 1 year. Those issues will start presenting themselves, and that is how you will have a useful and meaningful intervention when it comes to sexual violence and repairing. And I'll take you to Kenya when we had our public interest litigation, which is also one of the processes of the repair that we went through, and the thinking that litigation, of course, was going to be something that was going to be easy because of the when a country goes through war, the whole world concentrates on it. The way the world is concentrating on Sudan, the way they're concentrating on Palestine, and concentrating on Ukraine. But then after the body count, you think that because of there's so much concentration, different interventions, things are going in tandem. It doesn't really work out like that, because our initial presentation of the public interest litigation, which was in 2013, came to see a ruling in 2010 actually, 2010. And then thereafter, the compensation was given early on this year. And the compensation, out of the 8 litigants, only 4 got the compensation. And when the 4 got the compensation, they only got paid a few months ago. That in itself brought in a very different dynamics within the survivor movements, within the survivors themselves. Others felt that it should have been divided because we were also part of the process, that they were actually just they were a pilot case, and that they're the ones who had set the pace for us, and that money should have gone to it. Brought in a whole level of new dynamics. And so, what are some of the traps that practitioners fall into in regards to reparations and gender-based violence, and how do we avoid it? First of all, is the organizational victory vis-a-vis the survivor well-being and dignity. Because you have been given money for an intervention and you want to implement, you're busy ticking boxes. You're not thinking about the well-being and the dignity of the survivor. Who is the justice or the intervention or the initiative for? Is it for you, the institution? Is it for your expertise? Is it for you to get bigger funding? Is it for you to get bigger visibility? Is it for you to be known? Is it for you to be on the platform? Or is it for you to be known that you're on the grid because of your intervention? The justice is for the survivor. So that is one of the key faults. And also another thing is the extractive nature of institutions, because everyone wants to work and come up with data. And I've also realized them as practitioners, of course, data is very important, because how then do you present a case? But everybody comes up with data and say, we did this, we did that, we did this. And there's a lot of survivor fatigue around it, simply because when each institution that comes, they say that they're survivor centered, but putting a member of a survivor on the board who has no voice, whose interventions are not listened to, who is there really just like a figurehead, really does not matter. So survivor centeredness means the inclusion of their voice to be heard, and their voice to be implemented whenever they're in any space where they're placed there. And so another fallacy, I think, is also when institutions speak on behalf of survivors. One of the key things that made me start Grace Agenda was this business of first of all being considered as guinea pigs, because when there were conferences all the time, there were interventions, there was money in the country, everybody was doing this, everybody was in the justice sector, and people are taking up different initiatives. And so we'd be called to speak and to present and to be shown. And so we were like literally lab rats to be presented as evidence that the violence existed, that women were raped, that the women were violated, and there was conception that took place, that this was a consequence of the conflict, and that therefore they justified having their money, and so that they needed more money. I thought after a while, that's not really what I wanted. I didn't want to go there and you feel dirty. You feel, I don't know. I can't express what you feel. And you know, in this life, you remember more how people make you feel more than what people say. They'll always remember, and you make them feel in some kind of way, and they'll have something mental against you. Whatever it is, even if you come with what kind of intervention, they'll always remember how you made them feel, not what you said. And so that's what triggered me to start Grace Agenda, because there's a way in which we wanted to say something. We didn't know how to say it, but we knew we wanted to say it. So when our capacity was built by ICTJ, by PHR, by, of course, very recently, the Global Survivors Fund, survivors are able to express themselves more. I am a product of my capacity being built. What is it? Self-agency. When survivors speak for themselves, you cannot challenge the story. You cannot. Simply because you've given them the voice and you've given them the right, they've given their dignity, their intrinsic dignity is within them, and it has risen to speak and to know that this is me, and you cannot change me. When you give them their voice, you'll have won them over, and your programs and your interventions and anything that needs to run will run automatically without. So now let me give you a wonderful example. Who decides when transition has ended? What is transitional justice? Does it transit from conflict to non-conflict, from cessation of war, from the writing of a new covenant, from the agreement between warring factions, or is it from the presence of money for interventions? When does transitional justice end, and who decides when it ends? Transitional justice, from a survivor's perspective, and where protectionists also fail a little bit, is when justice is served. That is that is the end of it. When justice is served is when the transitional justice process has ended, because justice has been served. So I started Grace Agenda, and one of the key things I wanted, first of all, was that we would be able to speak for ourselves. We would be able to speak about reparations, which we knew very little about at that time, and that, first of all, we would remember our comrades who had died and who had been lost in the fight and who had been seeking justice. It is 17 years. I began by telling you, how do you put 17 years into 5 minutes? It's very difficult, comrades, but I've tried very much to present myself. But to avoid all of it, I think I've presented myself very well, is to co-create interventions. You must have them you must have the ideas, you must have their say. If not, you are thinking for them. Give them the dignity of voice, give them the dignity of listening. Because when you build the capacity of survival organizations and the networks for agency, they will speak. So that when the transition ends, when the money is left, when the guns are silent, when there's nobody else there left to speak for them, they can speak for myself. That's what I've been doing. Whether you give me money, whether you don't give me money, I will come and I will speak, because somebody still needs to hear it. What happens is that when you give them agency, they will speak. What happens when donors exist or the basket shrinks? Survivor-centered approaches will ensure that survivors speak. Thank you.
Thank you so much, Jackie. Thank you so much, here you are. Thank you so much for your very powerful intervention. And let me just reiterate that it's us who are very grateful to you for sharing your wisdom, particularly in such a powerful way. And I can assure you that, I know you don't see the room, but that we were all very, very closely listening to you. So again, thank you very much. Kobasia, may I now turn to you, please? Jackie has spoken about dignity as being one of the key priorities, about agency, indeed, for survivors, engaged in, indeed, sharing their leadership, sharing their wisdom with us, so that we can become much better in what we try to do. But how can we make that safe? How can we make that non-extractive from your perspective? Thank you, Kobasia. Over to you.
Yeah, sorry. Yeah, thank you very much, Alex, and also following Jackie, I really want to say very, very much appreciated, to be here and the opportunity that is, given, to me also as a survivor, to speak. Just want to, how many minutes I have? All right. All right, thank you. So I think, to answer this question, I have, some, because of the time, I'm just going to look at, the do and also the don't and all those sort of things. So just, create a list, per se. I think I come from the position where I said that, as a survivor, who best, can speak on my behalf, as, Jack said. And as a conclusion, I felt that, I will be, the best person, to put out my desire, my need, and also, I can challenge policies that are there to protect or to support me, which does the role that I believe that need to be done. And that's how in 2006 I put together this World Speak Out Network. The aim is that to bring survivors together in order for us to better represent ourselves and to better put our ideas, together. I think, next year is going to be 20 years. So that's great. So I think in that what I have learned, that creating safe and dignified space for survivors, it is not just about the goodwill, right? It's not about that. It's about structure, accountability, and also respect. I mean, too often, survivors are invited to speak, but not to shape the decision. I see, changes for the last, few years, happening. And when you just invite survivors just to speak, when they speak and, and everything is closed, that's a tokenism. And there's no real change come when survivors are not the co-designer, not the co-led, or also not the co-decided. I think you have to. So here are my core do. Number one is co-design from the start. Survivor should be helped to shape agenda, not just be added at the end. Do clarity and consent. Set transparent expectations and always give option to survivors to pause or to pass. Next point is do value expertise. Pay survivors for their time, cover the costs, and acknowledge their intellectual contributions. My next do is do provide support. Prepare survivors, before engagement and also after, and offer debrief and peer support, after engagement. My next one is do sustain engagement. What that means is that don't just invite survivors once for optic, but creating ongoing roles, advisory panel, leadership position, for survivors, to help you. Do protect confidentiality. Survivor must retain control over their own narrative. Ask before sharing, quoting, or publishing. But it's also really important, be accountable. Show survivors how their input changed the outcome. Without feedback loops, participation feels just extractive. So I have just a small list of don't. Right? Don't invite survivors only for symbolic presence. Don't push for traumatic disclosure to make a point. Don't overburden survivors without support. don't assume survivors are one homogeneous group. Intersectionality matters. So, I mean, for me, it's not, it is personal because it's emanated from, the lived experience. And from me, initially, reaching, the UK seeking protection, the way that I was treated, by the immigrations, by the services, by the support that I, received there, I felt that I was not treated with dignity, with compassion, and with respect. So that's why when I set up the Survivor Speak Out Network, I tried to put all those things. And since, 2006, 2007, I put myself forward to help, the community as a whole in order to implement, survivor-centered approach, which embed compassion, respect and dignity, valuing our differences and our diversity as a strength rather than, our weaknesses. Because survivor insight is so important beside, the, what is the terminology? Beside, academic expertise or, whatever that expertise that you gain without, having the lived experience. Those two combinations, the mix it just, created, the strongest position that we have. So to close, the message is simple. Self-engagement is structured, no accidental. Survivor must not be just in the room, they must shape the room itself. Thank you. I hope I did it under fire.
Thank you so very much, Kobasya, for that very clear list of do's and don'ts. Again, I saw many people writing, but I also reached out to you afterwards so that we can publish this list as well, including through some of the work that my colleagues are doing at the Women's Initiatives to put out a survivor engagement protocol so that we have a checklist to remind us of dignity and respect in engaging. So again, Kobasya, thank you very much, and I encourage you all to look up the work of the Survivors Speak Out, and congratulations on reaching almost 20 years. That is a great milestone. So now, Deborah, over to you, please. Thank you very much for joining us as the head of the Trust Fund for Victims. You within the structure of the International Criminal Court, you have shown leadership in making sure that you go from thinking about gender, having sensitivity to it, to really developing and now implementing at the institutional level through policy development and more. So can you tell us a little bit about that? Thank you.
Thank you, Alex. Thank you. First of all, thank you so much. It's such an honor to be listening and learning from all of you in the conference, but particularly in this panel. I've taken very good notes, and I hope that we can continue this conversation later on, because you have actually highlighted the challenges that institutions face when we have a mandate and we need to make that mandate happen. So I don't know how much people follow what is happening at the International Criminal Court, and we are weak in making sure that people can really understand everything that is going on, but it's actually very exciting. It is actually very powerful what is happening. We have, you probably have heard already, the Office of the Prosecutor, who have spoken about the number of cases and investigations that have been brought forward that actually have charges for crimes against humanity or war crimes for actions that constitute sexual and gender-based violence. And this is already pushing the needle forward very concretely with jurisprudence and with judicial processes that are complex and difficult to follow, but are giving us a lot of information that are allowing a lot of victims that participate in these proceedings to tell their story, to mark what is the truth for them, and for judges to listen in and then come with conclusions. So that is something that is very important for us. And the Trust Fund has a responsibility to look at that within the jurisdiction of the ICC and turn it into programs for the benefit of the victim that address the harm that is caused by those crimes. And that's what the ICC, from all the innovations that we can think of, is one of the most powerful one, in my view, which is justice is, as you said, accountability, but it's also addressing or redressing the harm, even if it's only recognizing it in a symbolic manner, because it's not possible to fully redress, to fully repair. So we've been working on this, and I have so much to tell you about, but I know that we are short on time, so we will be very happy to share with you more information. And we subscribe to everything that has been said here. We are trying to see how we make it happen, because the reality is that the smallest case at the ICC has around 300 persons. The largest case at the moment in terms of reparations has 50,000 people. So when we're talking about co-creation, co-design, participation, and doing committees for victims, it is of course very powerful. But how do you do it with a population of 50,000 people, many of which are victims of conflict-related violence, who do not want to speak up, who do not trust us, who do not understand what this is all about, and they don't feel safe to come forward. Some of them say, well, I am a victim of this or that, but I don't want to be recognized as such. I'm not interested in coming forward because I already experienced stigma from my communities. I am afraid of retaliation. I'm extremely ashamed of what happened to me, and I don't want to subject myself to it. So participative process are very demanding on the victims, and we need to figure out how we do this when that demand is creating harm or is not possible for us to put that for many reasons. And I think I want to maybe focus this intervention. I want to give you maybe a few data just to get you excited about what we're doing, but I don't want to dwell on it too much because I do want to maybe prompt some reflection and at least leave it for this conference to help us resolve. First, in the past 6 years, the Trust Fund has been intensifying its efforts at the level of programming, and in particular on SGBV. So we have implemented programs across 7 countries that have serviced 20,000 victims of sexual-related gender violence, sexual or gender-based violence, my apologies. And what does that give us? Where are we now? You're asking us, how do we turn this into something that is lasting? We're trying to learn from it. We're trying to gather experience and say, okay, what has worked? What has this meant? Jackie was speaking of, how we want to all create data, but we do need to learn. We need to create evidence of what our work is doing. We need to understand what is the effect of what we're doing. So data creation comes from learning, from being accountable, and we need to do it. And we're very excited that we are publishing our first outcomes report, our first impact report, where after 5 years of programming, we're measuring, okay, and then what? Okay, yes, impact at the individual level. How does this help you as a survivor? Yeah, and in which areas? And Jackie spoke of them already. Medical well-being, physical well-being, mental well-being. And you know what that means for victims of sexual gender-based violence, and our interventions do address that, from HIV treatment to surgeries that need to happen, obstetric surgeries, to socioeconomic well-being, and that can take many forms and depends on the different programs. We have a lot of experiences, from cash to income-generating activities to community-led socioeconomic activation projects. Then what does this do for the community, for the collectivity? And what does community mean? It starts with a family, with the relationship of many survivors with their own children, either born out of rape or not. It has to do with the relationships between the couples. It has to do with the relationship of that family with the other families in that community. That we have to remember, all this violence destroys the social fabric. This is what the Rome Statute says. It shatters our bonds. And that's what happens in these communities, that in scarcity and in fear and in trauma, we don't trust each other, we are violent with each other, we don't know how to deal with each other, so their own communities are torn apart. So how these interventions are also helping at the community level, how they're contributing to peace within ourselves, but also with the others, and therefore how these are contributing to conflict prevention. And very importantly, that sense of justice, that sense of recognition that comes from memorialization, from remembering, from the way things are done, as well as from the sense of justice, that you feel, well, the judicial process took too long and the perpetrator didn't get enough years as they should have, but I participated in it, I understand it, and now I can forgive if I want to, and focus on something else. And that sense of justice is very interesting, and this is very important, I think, is giving us evidence that these interventions actually increase the trust of individuals in institutions. And this came from asking about psychological well-being. And I want to touch on this very importantly, because as we move as civil society to protect, defend, resist, transform, we need to be mindful that what is happening really at the world is an attack against the rule of law institutions. And we run the risk of contributing to that by not thinking, how can our work strengthen those institutions? And I want to touch on this very importantly, and really recognizing what is happening in Ukraine, in the ecosystem of justice that has been created at so many levels with so many actors, that is a great example from what others we want states to respond. But I think it's very importantly the issue of, maybe I'll just to wrap up on 2 points. The first one is, we are as institution, as trust fund, as ICC, as governments, I guess, really constantly between tensions. Victims want reparations to come soon, to be broad, to be intensive, to be comprehensive, and to address the majority, a large number of victims. And institutions often need to make very difficult trade-offs, where either we do a small program to help a few group of people really well, or we do a program that can help more people in a much more less deep way, right? And these are trade-offs. And I think that what has been mentioned as participation from what we're doing in the trust fund, what is the most important, I think, central thing that we're trying to transform is that those trade-offs, it's gonna be very difficult to overcome them, because the world is shrinking, the resources are shrinking, the security is increasingly less available. But we need to make these decisions, and this is what you were making, in a clear way, in a participative way, so that we all understand why certain trade-offs are being made, and that we support the trade-offs, the difficult choices that have to be made. And I think this is a challenge. Why? Because we need to create trust. We need to be more collaborative. And this is maybe the second key focus that we're doing. We did it we mentioned it in our oral hearing in the Al Hassan case. 2 weeks ago, the Al Hassan case is now in a reparations phase. And it's a difficult case because the judges did not recognize and upheld the conviction for sexual gender-based violence. But we're still dealing with massive criminalization out of the imposition of Sharia law and religious persecution, which impacted women also in a very particular way. And what we're asking the judges is that they consider also developing, amongst the many principles that they have already developed, they've developed the reparation principle of participation, the reparation principle of accessibility. Very importantly, they have recognized the transgenerational nature of the harm that these crimes cause. That is in the jurisprudence of the ICC, and that hopefully will be coming at the domestic level to be taken on, knowing that, what happens to women or men today is going to be inherited to the future if we don't stop it, if we don't redress it. So we have asked the judges to expand on the principle of conflict sensitivity, because we also know that these interventions, as Jackie was referring to, also create tensions in the communities when some victims are recognized and others are not. And I think that the challenge that we all have as institutions, as practitioners, as survivors, is to try to overcome that immediate reaction of tension and conflict, and try to turn that into collaboration. How can we build on everything that we're doing? We are all playing a specific role. How do we build on that? And the big feminist saying is, remember, fear or flight, flight or fear, how is it? no, what is it? Fight or flight? Sorry, fight or flight, right? How do people respond to threats? Fight or flight? No, no, no. In feminism, we respond by collaborating. And there is evidence in nature that trees and insects and animals collaborate amongst themselves. And this is what we are trying to do. So yes, we can criticize the ICC. Yes, we can criticize the government is not doing this, the government is not doing that. Okay, how do we make it better? How do we build upon it? How do we make it better? Because we need each other. So those are the challenges. I'm sorry I'm not being very institutional. Now, I do want to share, because you asked us one key practice, one thing that we want to share. I want to share 3. Number 1, we are asking ourselves, what does success looks like? And we want to ask all of you, and we want to hear from everybody, for survivors of sexual gender-based violence, what does a reparative program looks like when it's successful? And we've heard already some elements. And we will, what is coming forward for us is that framework for measuring successes in the strategic plan of the ICC under Objective 5. And that is a very important project that we're working on, to have evidence, to have a consensus of what success looks like. The second one is that we need to recognize also the time element of, in the case of the ICC at least, we are coming to address survivors after a long time since the crimes have happened. It's been a long time. And the responses that we have on the number of national protocols are about immediate response and are not necessarily suitable for historic affectations. So that is one question that we need to ask ourselves, and we want to hear from survivors. How does it look like for you when it's been 1 year, 5 years, 10 years, 15 years? Maybe the response needs to be differentiated also in that sense. And very exciting project that we did in Central African Republic, an acquittal of Jean-Pierre Bemba for crimes, including important charges of sexual gender-based violence, and the Trust Fund intervened with a program that seeks to complement or step in even in the absence of that accountability. And from that program, we have assisted now 12,000 victims now in a period of less than 4 years. And so we have learned a lot. And what we've learned from it, very interestingly, is that while the interventions were being very positive, and we have the honor of collaborating with Mukwege Foundation, Danish Church Aid, and other local organizations in CAR on this, is that these projects are amazing, are powerful. Women end up dancing and really emerging and recovering themselves after enormous pain, and many of them in the border of suicide and living in the streets, not being able to work. The projects helped, but then when they went home, their partners, their fathers, their brothers were re-victimizing them. They were patriarchal, normative in terms of all the burden on the women, keeping all control of the cash, interacting in a violent way with the children. So we added the positive masculinities element in our project in CAR, and it is amazing. It is really amazing to see how this can be so transformative. So I think that what besides exploring those elements, I think what it also calls for, and maybe just to add to your list, also creativity and thinking outside of the box and thinking, okay, what are all the problems that we're trying to address? So I hope I've covered, very in general, so much to cover, but I want to be very respectful of the questions and your time. Thank you.
Thank you very much. Thank you very much, Deborah, for that. And once again, I encourage you all to visit the Trust Fund for Victims website to see what the immense work really you and your team have done on gender in policy and implementation, all the creativity indeed that you've brought with you.
Checked in the website, by the way.
Oh, good.
Visit it soon.
Okay, well, visit it soon, not right now, not right now. Dear friends and colleagues, I am a little bit forced to close this meeting reluctantly because we're already 15 minutes past time. But once again, I do encourage you to come up, talk to our speakers, connect with Jackie as well online. And let me end on a very big thanks to the 4 of you for, again, being part of this journey that we're on of knowledge, of understanding how we can become better as an ICL practitioner community. And with that, I'll release you for lunch. Thank you.
and the continuum of structural discrimination with all of these amazing experts. So as a starting point, Priya very wisely suggested that we actually maybe level set and define structural discrimination at the top of this conversation, because it's one of those topics where we often find that we're not all meeting in the same place about what it is. And so from our perspective, we've looked at it as a panel. So what we're using is the fact that structural discrimination refers to systemic and institutional policies, practices, and cultural norms that perpetuate inequality and discrimination. Unlike individual acts of discrimination, it is embedded in the fabric of society, influencing how resources are allocated, laws are enforced, and opportunities are distributed, and requires that we look at multiple and interlocking systems of privilege and oppression, including sexism, racism, xenophobia, colonialism, homophobia, and transphobia that drive discrimination. And so, while we've made some progress in understanding structural discrimination, the recent case in the Al-Hassan, or the recent decision in the Al-Hassan trial at the International Criminal Courts reminds us that we have a ways to go to unpack and understand how gender-based targeting and harms are understood within broader contexts, and it's clear that we need to keep pushing. We also see some signs of hope. Our panelists are going to describe today how they approach structural discrimination in their work, but I'll briefly highlight one example from my work, the ongoing efforts to codify the crime of gender apartheid. The work to codify gender apartheid is grounded in the fact that under the framework of ICL, we do not have a crime that recognizes the systemic oppression and domination on the basis of gender. So the legal gap that the codification of gender apartheid targets is precisely regimes that institutionalize such systematic oppression and domination. So with that, I'm going to turn us over to our amazing panelists, who I'm going to briefly introduce. So first, on my left, we have Emily Palame-Pradeshit. Emily is a decolonial and intersectional feminist, international human rights lawyer, and founder of the Manusia Foundation, a feminist organization based in Thailand, grounded in lived experience, liberation, and true decolonial solidarity. Born stateless as a Lao refugee, she defends frontline communities, including this morning, challenges authoritarianism, and strengthens intersectional movements to dismantle oppression across Southeast Asia. Next, we have Paxton McCausland. Paxton is an organizer and academic who began working towards gender justice as a grassroots organizer for transgender liberation. They were recently appointed as a board member for the Women's Initiative for Gender Justice and received a Master of International Public Affairs from the School of International and Public Affairs at Columbia University. Next, we have Brishna Kach. Oh no, I got it wrong. No, I'm going to make you say it one more time for me. Kashach. I'm sorry. I hate when people try not to get the names right. So Brishna is a feminist sociologist, former president of the National Union of Guatemalan Women, one of the plaintiffs in the Sepra Zarco case. She's currently the gender program director at Impunity Watch Guatemala, where her work focuses on women's rights, including sexual violence during the 36-year internal armed conflict in Guatemala. She's done research on CRSV, strategic litigation, militarized masculinities, transformative reparations, and has supported survivors, including the Maya and Achi women. And last but certainly not least, on our far end, we have Priya Gopalan. Priya is an international criminal lawyer from Malaysia, and she was a prosecutor at the ICTY and the chair rapporteur of the UN Working Group on Arbitrary Detention. So we have just an absolutely amazing panel, I think, to talk us through this, and we are hoping to engage in more of a conversation between the panelists as well as with all of you. So I'm going to be holding our panelists to be brief in their opening remarks. So Priya, let's start with you. How does intersectionality help to surface structural discrimination in international criminal law? What can we learn from historical experiences of such discrimination and efforts to hold them to account, including those who experienced militarized sexual slavery during World War II?
Thank you very much, Akila. And I'll count on you to hold me to account when I have 1 minute left, if you don't mind. Thank you. Thank you, everyone. I'm going to go straight into it. I'm going to start with a brief introduction, scene setting for what I mean by intersectionality for the purposes of our discussion. And then I'm going to zoom into the example that Akila mentioned, which was militarized sexual slavery in the Second World War, and how intersectionality will allow us to analyze that crime. Now, while the concept of intersectionality has its roots in community-based feminist movements, it was Kimberly Crenshaw, an African-American legal scholar and lawyer, who coined the term intersectionality in 1989. And she used this term to describe the simultaneous and intersecting bind of racial and gender discrimination faced by Black women in the employment context in the USA. Now, her focus, Crenshaw's focus on the intersections of gender and race, highlighted the need to account for multiple grounds of identity and considering how our social world is structured. So her conception of intersectionality was a response to anti-racism and anti-sexism legislation in the US that was anchored on the protection of Black men and white women, respectively. And Crenshaw says that this left Black women theoretically erased because the feminist and anti-racial policies that gave rise to these laws were predicated on the experiences of Black men and white women and failed to capture the experiences of Black women, the interactions of race, gender, and class that they experienced in the employment context. And this discussion was had in the context of several cases. So it was a legal process in which the legal outcomes of these cases highlighted the conceptual limitations of a single issue analysis. And this is where intersectionality comes in. Now, I will also be remiss not to add Patricia Hill Collins. She's another African-American legal scholar, and she approaches this idea through the concept of the matrix of domination. And in her conception, the focus is on structures of oppression. So while we had Crenshaw looking at identity, individual factors of identity, race, gender, class, Crenshaw looks at the matrix of domination as an overall organization of power in society. She argues that heteropatriarchy, neocolonialism, capitalism, racism, and imperialism constitute forms of oppression that take different forms and therefore catalyze social inequality. So coming back into our discussion today, ICL, where does intersectionality fit in? Now, against that backdrop, we see that at its core, what intersectionality does is that it reveals unique and compounded forms of discrimination that result from intersecting structures of oppression. So in a nutshell, intersectionality analyzes and demonstrates that the sum of discrimination is greater than its parts. So what it does in the context of ICL is that intersectional discrimination can result in specific harms that are distinct from the discriminations that arise when we assess each individual factor separately. So bringing this all back to the example that Akila mentioned, militarized sexual slavery during the Second World War, what does intersectionality add? I would argue that it makes visible what is excluded and unseen at first glance, and therefore it draws out what has fallen through the cracks in the justice chain. And why is this relevant? Because these factors are relevant to understanding victims' and survivors' experiences and inform the justice that they demand. Now, the case of the sexualized military sexual slavery of women and girls by the Japanese military during the Second World War, as many of us know, is a notorious case of sexual and gender-based violence, and one for which accountability has been almost non-existent. This occurred during the Second World War, and estimates indicate that up to 200,000 women and girls were captured and forced or tricked into sexual slavery. They were drawn from China, many of them, and various countries in Southeast Asia and the Pacific but mainly from Korea, which was then a colony of Japan. Now, what can intersectionality tell us about the crime of sexualized enslavement? Pyonggap Min writes that in the case of these women and girls from Korea, Japan's colonization of Korea was a critical factor to their enslavement. A state-supported patriarchal system in Japan facilitated the establishment of the military brothels in which these women were detained, while patriarchal customs in Korea perpetuated their further victimization when they returned home. These women and girls were largely drawn from impoverished families, and they were enslaved in part due to their economic and social status. So consequently, when they were eventually freed from slavery, their future prospects remained constrained, with some of them even being forced to return to sex work for reasons of economic survival. So here, what we see an intersectional analysis does is that it reveals that these Korean women and girls, gender was a relevant factor, obviously, but along with gender, a driver for their enslavement was colonialism, ageism, patriarchy, militarism, and class. And all of these factors then coalesce to produce the unique violations that they suffered when they were enslaved, and also that they continued to experience after their period of enslavement. So what intersectionality has done here is that it has revealed further relevant elements of the individual experience of these women beyond what a gender analysis would reveal. And this is why intersectionality is relevant. And we heard this morning during the panel on women and girls in Palestine. I believe it was Rana, the deputy DG of the Women's Center for Legal Aid and Counseling from Palestine, who talked about the impact of Israeli colonial policies and patriarchy in Palestinian society, and how these two factors impacted the experiences of Palestinian women who were seeking family reunification. So how am I doing for time?
You're done.
And with that, I will conclude.
Thank you. Thank you so much, Priya, for, I think, really clearly laying out through an example how we really can approach this lens and what the lens brings to it, and for connecting it to this conversation this morning as well. I think that's really, what we're hoping to do with all of these discussions is formulate this ongoing conversation. And so Brisna, let's zoom in next on what it looks like to pursue gender justice for gender-based crimes within patriarchal and racist systems. The Seprazarco case and the Achu women's cases from Guatemala are landmark cases that deliver justice and reparations for sexual violence for Indigenous women. Can you share more about these cases and what lessons we can draw from these experiences?
Yes, thank you. I brought a presentation that's, I don't know if it can be shared, so just to show a few examples. I think the previous presentation is a perfect sort of drawback of how the legal systems are already sort of structured in a way that limit the procedures, but also just the experience of sexual violence are structured discrimination in themselves. So I'm not going to focus too much on what happened to the women, but the legal processes themselves and sort of the challenges that they faced in some of the cases in Guatemala's experience. So I want to talk about some of the cases that have been brought to justice. As you know, Guatemala, we lived a 36-year conflict that was very much rooted in the racism and sexism, and this affected primarily indigenous population. The most brutal crimes, the massacres, the genocide, the sexual violence, you can see the brutality is mostly against indigenous people, even though the perpetrators or the elite might say it wasn't a genocide. They will continue to deny it, and that it was a Cold War sort of framed war. You can see the racism behind and the colonialism in the country. 93% of the perpetrators were state security forces. So I think this is also important to keep in mind because the perpetrators are linked to power and to the economic elite who continue to have power in the country. And this also has an important impact on how changes or not can proceed in the country. So we've had some cases. Maybe yes. Thank you. So thank you. So as you see, we have some cases that have been brought to the justice system. Most of you have probably heard or learned more about the Sapur-Sarco case. This was the first case that concentrated primarily on sexual violence, sexual and domestic slavery. But before that, we had the genocide, the Chile genocide case in 2013 against the dictator Efraín Ríos Montt. Unfortunately, that was appealed by the economic elite, and that case had to be repeated in 2018. But that case did include sexual violence in its process. And then the Molina Tyson case in 2018 against a woman that was detained, arbitrarily detained, and was raped while she was detained. But it was also about her brother, 14-year-old brother, that was enforcibly disappeared. And then the Achi woman's case, also about women that were enslaved and raped in a military detachment in the community of Rabinal. Now, this case is also emblematic because Rabinal was the municipality, the region where paramilitaries had the most crimes committed. They were the most responsible, highlighted by the Truth Commission. It shows how the military trained, organized, and armed community men to attack its own community. So the Achi woman's case demonstrates that military use at the community level. There's been two trials, one in 2022 and two in 2025, because the legal process dismantled the case. So that's why it had to be like that. So some of the things I want to talk about is that for these cases to move forward, there were mechanisms created, and that is important to recognize. The peace agreements and the peace process did create certain mechanisms that were important, but because it is created within a structure that is racist and sexist, it has its limitations. So all of these cases were brought before specialized tribunals. They're called the High Court tribunals, and they specialized in seeing cases of organized crime, high-profile crimes, including cases of the conflict. Now, some of the limitations of these cases is that they are in the city, so they are centralized. Obviously, it's judges that are specialized, so that is good. They are brought by a specialized district attorney's office that was created. That was also good because then it's specialized prosecutors, and that was good. Some of the limitations is the centralized settings of these specialized courts, but then there was also security issues that had to be considered. Here we see the images of the victims of sexual violence giving their testimonies in the genocide case and then the Sapur-Sarco case, which is important, but the responsibility was put on the victims. So that can also be victimizing, and not so much on the prosecutors, for example, the accused. If we can move forward with the other aspects was the language barriers and the need to use interpreters. In the Sepur Sarko case, I think one of the most important things was that it did use strategic litigation. And they trained their own interpreters. And this was important and this was key because the women and all the witnesses trusted the interpreters. And the interpreters also understood what had happened. They understood the legal language. And this had a good impact in the sense that the judicial system now has its own interpreters. But the problem now, and in the Achi woman's case, you see the interpreters from the legal system, is that they don't understand the context, and the victims don't really trust them because they don't know who they are. They don't understand, even though they're from the judicial system, they don't really know how to translate adequately, culturally and legally. So let's say, for example, an Achi woman might say, to say that she was raped, she will literally say, a man went over me. And so this would be questioned, because then the defendants would say, well, she's not really saying that she was raped, So you need this sort of understanding of how interpreters can really transmit what the victim is trying to say, but also understand that legally how to translate these sort of things. And other barriers, we can go to the next slide. Well, no, here I want to talk about some of the lessons learned or the importance was the strategic litigation. In the Sepur Sarko case, this was a case litigated by different organizations, feminist organizations, Mujeres Transformando el Mundo, which was the feminist legal organization, UNAMG, which is the organization I come from, which is a feminist organization that was mostly focused on empowering the woman. And then we had a community, psychosocial community organization that supported with the whole psychosocial aspect. But then the victims themselves organized themselves and were plaintiffs as well in the process. And then in the Achi woman's case, you will see in the next picture, was the importance of having Achi and other indigenous lawyers. This is the first time that indigenous lawyers defended and litigated in favor of the victims. This is also another step forward that changes and challenges the legal system, where there's this racist imaginary that indigenous women are servants. This is the Guatemalan imaginary. But to have indigenous women lawyers in the legal system litigating also ruptures this system. And they had their challenges themselves where they were not respected as much, but towards the end, they were recognized as the lawyers of the Achi women. So I just wanted to recognize that and also recognize that the women now, after they have reached sentences, they are seen as leaders in their community. So this shifts their point of view. So the next two pictures are of the women, the Sepur Sarko women and the Achi women. I'll leave it at that. We can continue later.
Yes, and you can hold on to that one. No. Person, thank you so much for that. And I think, we often cite these precedents as successes, but it is important to not forget what it took to get there and the challenges and really what it means to confront some of these hierarchies that are present, even though at the end of the day, we often say, well, that was a big victory for gender justice. So really appreciate how you drew those out. And Paxton, we're gonna go to you next. So Brisna has surfaced the challenges that Indigenous women faced in Guatemala. Let's turn our eyes to another population that's often marginalized in justice efforts, LGBTQI+ individuals, and in particular, trans individuals. How can international criminal law better recognize, protect, and deliver trans justice?
Thank you, Akila. I usually don't get a microphone. I usually just have to yell. But yeah, I just wanted to say thank you before I start. I'm very honored to be on this very tiny stage with these inspiring women. Very excited to have been invited. Yeah, very happy to be here. There's a lot that ICL and the ICL community can do for trans people. international law, as I will get to, is actually very good for trans people. The first thing you can do is listen to us. One of the biggest issues that trans people face internationally is prejudice and discrimination. And the easiest way to combat this is to know us. So thank you for listening to me. I really appreciate it. I am, however, just one person. We are a very intersectional community. We are on nearly every single continent, if not every continent. We have been around since the birth of humanity. We are an extremely beautiful and natural variant of human nature. And yeah, listen to us. Amplify our voices. We are not heard quite often enough, nearly enough. And I am also here as, you know, a white American, very well educated, somehow with a beard and a mustache, very rare for a trans mask. But yeah, and I've also been granted male privilege. So go and listen to differing trans voices and make sure that when you find trans media, it's actually written from the narrative of a trans person. Do not watch The Danish Girl, okay? Freddie Redmayne is beautiful, but he is not a woman. Yes. So yes, so please listen to us. Additionally, another large issue that trans people face internationally is the lack or the inaccessibility of legal gender recognition. So I've gotten this, the concept of legal gender recognition, or LGR, from an academic that I really appreciate named B. Kaminga, who is from South Africa. They've done a lot of work on trans-forced migrants, or TFMs, and they defined legal gender recognition as the official recognition of a person's gender identity, including gender marker and name, most often through key documents such as passports and birth certificates, and in population registries or public registries. It has been cited, I believe, by the United Nations that the entity that this falls on is the states. However, there are many states that either refuse to acknowledge this or grant it or are unable to for whatever reason. And when an individual is unable to access legal gender recognition, it essentially makes them de facto stateless. And I think that that's something that not many people really recognize. And when somebody is unable to access this, it makes it impossible to vote, to rent a car, to rent a home, to open a bank account. Individuals lose an immense amount of social and political rights. And it's also can very much add to discrimination and prejudice, such as not being a legal citizen or not being able to prove that you are a legal citizen. And we need to be advocating for this on the basis of self-determination alone. There are many states, including my own, many parts of my own country, the United States, where people have to prove their gender or their sex. And oftentimes this actually comes at the expense, or the proof that is necessary is bottom surgery, which is wrong for many reasons. And the first of all is which not all trans people want these surgeries. They are invasive, they are extremely expensive. It's not just one surgery. We're not all Caitlyn Jenner. We don't get to disappear into our, Hollywood homes and pop out on the cover of Vanity Fair. It takes a very, very long time. It could be up to 3 to 4 surgeries. Additionally, that is forced sterilization, which is which is violence. It is reproductive violence, right? So we need to be doing it based on self-determination alone. And that phrase, self-determination, is beautiful because in my point of view, trans liberation at its core, when it is fully realized, is the absolute and utter unbridled expression of self-determination, right? Cool, not. Right, so we need to be advocating for that from an international level to the state level. So go and talk to your nation of origin, go talk to your representatives, make sure that that is a thing that people know about. Additionally, we need to advocate for a gender competent court. I would love that. If any, I know that there are organizations that are working to help get the ICC and the OTP of the ICC educated and gender competent. If you could get me in there, you wouldn't need to fly me out. I would grow wings and get here on my own. That would be so much fun. Please let me do that. It's highly important. I love that you all are here. I'm so thankful that you all are here. However, we are one drop in the bucket of ICL. And we do not hold all the power. I wish that we did, but unfortunately we don't. So we need to get the people that are making this legislation and enacting law and interpreting law to understand gender truthfully and honestly and correctly and accurately. The final point that I wanted to make is, yes, international law is a very, very good, or has the potential to be very good for trans people. I remember being an undergrad and having taken an American domestic constitutional law class and thinking, wow, this is boring and lame. And it is, it really is. And then I started to learn international law and I was enthused because written in international law is the codified, it's everything that we need for trans liberation, right? So let's make it work and make it happen. Obviously, we need to fight the impunity, obviously. But at its core, international law has words like self-determination. It actually has a definition of gender. I'm not saying that I like it, but it exists and it's incredible and that's so exciting. So yeah, let's use it. I know that, as we say, the future of international law is domestic law. And if I could one day in my life see domestic American law reflect the language of international law, I could die happy. So please, I would love to see that in my lifetime. And I will work to it as well. If I'm able to do it, we will see that. But yeah, I will leave it at that, at a happy note.
Thank you. No, I think, listen. We need more optimism in this moment. So thank you for that. But also really thank you for, I think if we think about the topic of this conversation and we lump LGBTQI plus together and we think that there are singular experiences. So I think hearing you talk about what, understanding specific parts of trans identity and what that means and how that plays out is really something that helps us go deeper in the conversation. And so really thank you for that. So Emily, we're going to turn to you, and we cannot discuss structural discrimination in international criminal law without addressing colonialism and its role in both the formation of international law and how it continues to inform who is protected and how. How do we as advocates build the imperative of decolonization into our work and ensure that in our efforts we upend, not reinforce, the colonial underpinnings of international criminal law?
Thank you, Akila. Thank you. I'm very honored also to be with all of you on this panel. Thank you for the organizer for organizing this important and creating this space for this important panel. You're giving me the hard question about colonization, but you're absolutely right. We cannot talk about structural discrimination in ICL without naming colonization and colonialism. ICL was born colonial, and it still carries that DNA today. International law was not born neutral. It was born colonial. It was designed to protect empires and capital, not the people. And so when I say colonialism, I also mean the power dynamics that it creates between the North and the South, and between elites and communities. And so I think we really need to be honest that ICL was not designed to deliver justice for all. And I think our panelists before me explained that very clearly. Structural discrimination is a colonial legacy. Colonialism shaped who counted as a survivor, whose crimes were prosecuted, but also what harms become core crimes. And so if we look at survivors from the Global South, they were brought in to tell their stories as sources of testimonies to build cases, but rarely given the power to lead or define what justice really meant to them. They were always positioned as victims who tell their story, never as leaders shaping the case, setting priorities, or defining what justice should look like. The experiences are filtered through the lens of white international lawyers, prosecutors, and judges, mostly from the Global North, who control how the stories were framed, what crimes were charged, and which parts of their lives matters legally. So this creates a dynamic where survivors are present, but their agency, the power to lead, to define, and to act is erased or minimized. Now, if you look at colonial atrocities, from slavery to mass killings of colonized people and indigenous people, we see that colonial atrocities are rarely prosecuted. Colonial atrocities were almost never prosecuted because international criminal law was built to punish the enemies of empire. It was never to punish the crimes perpetrated by the empire itself. Even the way crimes are defined shows a colonial mindset. Harms like dispossession of indigenous people, stateliness, silencing of dissent, or exploitation by corporations are treated as background, not as crimes in their own right. And so that hierarchy is still with us today. And the structures of international criminal law too often serve elite interests. So who fund cases? It's mainly northern donors. Who argues them? It's often international lawyers, not the community leaders. Who benefits from the judgments? Sometimes government and institutions, while survivors always remain without reparations. So this is structural discrimination at its core. It is colonial, patriarchal, and elitist. And I see it every day in my work as an international human rights lawyer in Southeast Asia. So what does it mean to decolonize ICL? It's a very hard question. But you know, for us on the ground, it really means that ICL, we need to admit that ICL was built on discrimination. It's making sure that our work challenges those colonial roots instead of repeating them. So first, it means that colonialism as a structure of oppression that still lives inside the law. We need to name it. Colonialism as a structure of oppression that still lives inside the law. Second, it means shifting power. And when it means shifting power, we mean it for real. So it means from white international lawyers in The Hague to survivors and communities in the Global South on the ground. Like in the case presented by Brisna, indigenous lawyers recognized as the lawyer of Ashi women. This should be the norm, not just a success story, but it should become the norm. From northern donors who dictate agendas to feminist movements who live the struggles on the ground. From elite legal categories to survivors' lived realities. And third, it means naming the class and elite dynamics that shape ICL. Too often, justice becomes an elite project, and sometimes, like we saw earlier today, it becomes a marketing project to get funding. Totally disconnected from the survivors it is meant to serve. So decolonization means refusing to reproduce those power dynamics inside our own movements. And because at the end of the day, ICL cannot deliver gender justice until it is decolonized, until it stops reproducing the very systems, colonial, patriarchal, elitist, that it claims to fight. And I love this quote, you know, from Audre Lorde, that says the master's tools will never dismantle the master's house. So it really starts with us in this room. If we really want to decolonize ICL, it starts with us. We really need to reflect on who owns the master's tools. Are we in a master's house? And how are we going to dismantle it to make sure that we can decolonize ICL? Thank you.
Thank you, Emily. And I think what you've just laid out perhaps prompts us to go into what I'm hoping is a conversation amongst the panelists, which will then open up to the audience as well. So, you know, picking up right where you left off actually is really thinking about how the comments so far have really identified how the pursuit of gender justice requires navigating structural discrimination, but that it's very much intertwined with the fact that the very structure of ICL itself is discriminatory. How core crimes are defined and what it's taken to surface gender-based experiences within the framework. And as Marina noted this morning, the fact that ICL is inherently patriarchal. So Priya, maybe let's start with you, and then I welcome anyone to come in after Priya. How should we be thinking about navigating this inherent contradiction, a need to engage with a framework that is built on discrimination to deliver justice and accountability for discrimination?
So a simple question then, thank you.
We're keeping it easy after lunch, that's the thing.
And it's a tough one to follow after, you know, the fellow panelists who've really given a lot of food for thought and insights. And I'm just going to pick up on some of the points that have already been made and perhaps answer the question from the perspective of what intersectionality can add as well. I mean, it's already been made clear that the project of international criminal law is one that has been founded on, racism and colonialism, and it's been clarified the role that certain actors have played as well. And I thought this is an interesting panel maybe to read a quote by the former prosecutor of the Special Court for Sierra Leone, David Crane. It appears in an article called Dark Corners of the World. And he had written in a journal article, in the dark corners of the world lurks the future of armed conflict. The real threat to humanity on several levels is bred in the fields of lawlessness in the third world. Conflicts in these dark corners are evolving into uncivilized events. So on a positive side, I don't think this language is going to be appearing anytime soon in journal articles, hopefully. But I think it does set the scene as to some of the issues that have been raised in terms of who are perceived to be the perpetrators, who are perceived to be the victims, and who are those who are delivering justice. And here I think intersectionality has a role to play in decolonizing international criminal law. And as Emily has mentioned, by drawing our attention to re-envisioning the crimes that need to be captured, acknowledging that traditionally international criminal law has not captured crimes that should have been captured. For instance, crimes committed in the colonies by colonizing powers, which occurred at the same time with other crimes that were prosecuted in Nuremberg, for instance. So structurally, this is the gap that we talk about in terms of the historical basis for international criminal law. But I would also like to add that aside from the structural gaps based on these aspects of colonialism or racism, we live in a time where alongside the structural gaps, there is clearly an issue with the selective application of international criminal law, where you have arrest warrants from the ICC that are not enforced, and those who are working on certain cases at the ICC are sanctioned for their involvement in what is meant to be an international justice project. So I think we need to separate the enforcement of international criminal law and also its racist nature, or the fact that the gaps are linked to the powers that created it and the roots that those powers have with colonialism. So that would be the sort of background to the discussion. And bringing it back to the issue of gender, so we've talked about crimes that perhaps were not acknowledged. I think Emily mentioned that somewhat in terms of the gaps, but what we can say also is, as written by Sujit Xavier and John Reynolds in this article of theirs called Dark Corners of the World, the ICC's catalogue of core crimes is rooted in a restrictive conceptualization of violence that by design cannot address many of the collective interests of the global South and peoples that are impacted by structural violence of economic cohesion, resource extraction, global wealth distribution. So what we see here is a hierarchy of harms. We have certain crimes that have been prioritized in the Rome Statute that have the status of core crime. But we also know that historically there have been other crimes that are more relevant or have been more relevant to other parts of the world, the global majority, for instance, that haven't made the cut, so to speak. So we talk about these gaps, and linked to that, and what an intersectional approach can add, is what are the root causes of conflict? Why are these gaps there in the first place? What are the roles that different countries play in causing these gaps? For instance, to what extent does the involvement of foreign powers meddling in the politics of other countries that then lead, perhaps motivated by political interests or economic interests, which then drive conflict, that then find themselves being prosecuted at the ICC. So what I would say in terms of addressing this question is to really have an interest in the root causes of conflict, to ask what does intersectionality contribute, and we talked about it at the outset in terms of understanding the structures of oppression, whether it's colonialism or capitalism, to what extent does wealth extraction drive conflict. So it would really be to have a holistic approach in terms of analyzing crimes and the root causes, and to be very aware that the crimes that we are prosecuting within the framework of core crimes is inadequate, to say the least. And I will just conclude with just some reflections, I would say. So we have, in this discussion, identified the significance of what is included and what's not included, whether it's in terms of crimes that we prosecute, and within that framework, I'd be curious, for us to think about, for example, in the arrest warrant against Benjamin Netanyahu and Gallant issued by the ICC, what was charged was the crime of starvation, relating to lack of access to humanitarian aid. Some have argued that the background to the starvation aspect was a wholesale destruction of food systems, water systems, aspects that are to do with living. So that is a gap. And on the other hand, we see that the Special Rapporteur, Francesca Albanese, in her report entitled Genocide as a Colonial Erasure, makes these links between the various crimes and the state of affairs on the ground. And so we can ask ourselves, why are these gaps manifesting? That certain crimes are charged and certain crimes are not charged. So that's one aspect to reflect upon. Is it the personnel or is it the structure of ICL per se? And I will just conclude with the historical challenge that we have faced in terms of addressing accountability for sexual and gender-based crimes. So in this case, the legal framework is there. International criminal law, international humanitarian law does have the framework to prosecute these crimes. But yet, in the example that we spoke about, the militarized sexual slavery of women in the Second World War, that remains a notorious example of impunity. And as many of us in this room know, accountability for sexual and gender-based violence has been a long-standing challenge. So these would be the different aspects, I think, through which we can reflect upon this question. So no answers, just some reflections.
Well, the question was so easy, so I'm surprised you didn't just get there. Do any of the other panelists want to reflect on Priya or on the prompt?
Okay. Thank you, Seno. It's a difficult question. But I think ICL is necessary, but it's insufficient. And I think we need to look at, building on what I was saying earlier, I think we need to look at ourselves, but also the way that we work, right? And it's always a very difficult exercise to self-reflect, to have that really uncomfortable discussion among ourselves as a movement. And so, yes, ICL is necessary, but it's insufficient because survivors should not be forced to twist their lives into Western legal boxes. And our role is to both engage with ICL strategically, but also to build survivor-led spaces of justice outside of it, so we don't reinforce its colonial limits. And we always hear people talking about we need to build survivor-led spaces, but what does it really mean? So when we work on the ground, and I'm working at the regional level, so I can be on the ground with Rohingya women or indigenous women, and at the same time, I'm dealing with NGOs and international lawyers. And I think the way that we work as a movement, it's very colonial. And I think we need to be able to talk about it openly. You know, when you have an NGO that comes on the ground to collect data of Rohingya women who have been raped without wanting to bring them to The Hague, you know, forcing them to testify without having any awareness and understanding of how to work with them. First of all, to build trust. How do you build trust? And I think sometimes the way that I've seen NGOs working is I have the funding, I have the funding, so I have the power, right? Because again, ICL is colonial because it also comes with power dynamics from the elite. And in our field, when we talk about the people who are meant to protect and support survivors, we also talk about the elite and the power that lies with the elite. Money brings you power. So the financial power that NGOs carry with them can also be dangerous for survivors on the ground. And sometimes you have, you know, survivors of rape and Rohingya women telling you, I felt that I was forced to talk to them. Also, I was traumatized by the way they handled the case because they have the financial power. And I think it's really important to reflect on that because unless I come and tell you, they are not going to tell you. And why they're not going to tell you? It's because they are scared and afraid of losing the little connection that they have with you. And you know, they don't realize that you just came to collect some data to put it in your documentary or to put it in your report. So you can be the, you know, we like to say on the ground, the American hero. But that's a reality. But they are not going to tell you to your face because they will be too scared to lose that little connection or even to lose that, you know, $500 that you can give them, you know, for 6 months. So I think it's the way that we need to challenge that discriminatory framework of ICL. It's also in the way that we work. If we really want to be able to challenge it, we really need to change the way that we work with survivors and the way that we work with people on the ground. If I look at the room, we are a minority coming from the global majority. And how long would it take us to have conferences in the global majority? You know, or why don't you come to us, you know, to have those conferences so you will be with survivors in the room, you know, rather than me trying to channel some realities on the ground. How we also, us on the ground, can build the power of survivors in the room so they can tell you how they feel in the way that you treat the cases or you treat them as survivors or hoping that they will testify with you in front of a diplomat so that you get more funding. Because in the end of the day, our field is still a business, right? In the end of the day, people are still making money out of survivors' testimonies. So that's really what I hate the most in our field, is how it is already discriminatory. It was already built on colonial legacies. And the way that we work, we are just reinforcing it. I say the way that we, because I don't want to point out of anyone, but I actually don't want to say we. I don't want to include myself in it because I want to make sure, because I make sure I don't reproduce that. But I say we as us, as a movement. And so I really want to encourage all of us to look at how to really build survivor-led spaces. We need to be able to create a space that feels safe for them rather than scary to them. We need to make sure that when we go to them, we have built trust. We need to make sure that there's no language barriers. So I love the case of Brisna, you know, when you have interpreters that actually already know the legal languages, and in the end of the day, indigenous women becoming their own lawyers. And that should become the norm. It's so important to build trust. And I know that we talk a lot about decolonization and localization, and I also want to raise the alarm of people talking about localization, because we see it more and more coming in our region, especially with the funding cut. Localization doesn't mean that an NGO is going to open more offices on the ground and bringing the international staff on the ground, because that's perpetuating colonization. Decolonization means that you build the agency from people on the ground. And as many of us who are international lawyers, we also need to think as our role. Like the international human rights lawyer who is the American hero, like I think this framing needs to stop. unless you really want to, unless you're studying international human rights law and you really want to bring your knowledge and your support to the communities on the ground on an equal basis, but always asking them, what does justice mean to you? And you know, like we are in the room of expert, but when we're on the ground, the expert of the communities. When we talk to them, we tell them, you're the expert. I'm here to learn about you. I'm here to learn with you. And what we have with us is the law. The law is our tool. But if the tool that we use is already discriminatory, it's our role to make sure that it's not discriminatory to the people that we serve. So I really want us, to reflect about the role that we play. And for me, coming to international criminal law conferences is really different from joining a movement building gathering, for example, next week. Well, I know that the majority in the room will be people from the global majority, so we'll speak the same language. So my goal is not to make you feel bad or anything, but I think this is uncomfortable conversation that we must have. Otherwise, we will never be able to challenge the coloniality of ICL.
Thank you. And I'm going to thank the organizers for giving us more time on this panel than some of the others, because I think that the richness of the discussion is really coming out. Brisner Paxton, do you want to add anything here? Yeah, there's a microphone right there, Brisner.
Yeah, I think that it's important to sort of think about the opportunities that we can think about and take. I think Guatemala's example shows us how at times cases couldn't be brought at the national courts. So they were brought at the international level. But that has its limitations as well, because for us, it was the Inter-American Human Rights Courts. And yeah, some of those cases did mention how sexual violence occurred. Even the Achi case is mentioned, like what happened to the Achi women is mentioned in one of the cases, Chichupac versus the state of Guatemala. And one of the measures is that the Guatemalan state needs to investigate this case. So those sort of measures are important. And I think it's important that the ICL sort of supports national mechanisms and national courts and procedures to be strengthened. But we also see that that has its setbacks. And in context of conflicts, there will always be groups that will try to sort of dismantle those advancements. And we're seeing that in Guatemala right now today. We're seeing those judges that were in those specialized courts, for example, being attacked, being criminalized for their decisions, not only in cases of transitional justice, but of cases of corruption, of cases of organized crime, and that have to leave the country. We have a veterans foundation that has been a plaintiff in so many cases, and they manipulate the law and they attack cases. They attack former prosecutors. They attack judges. They have a narrative to deny what happened. They defend military. And so some of the cases, like the Achi women's case, move forward in two trials, but because it was against paramilitaries that are lower rank militaries. The victims had also wanted to include higher military rank, but the prosecutor's office did not want to go for them, for example. In the Sapur Sarko case, there was other men that could have been included, but that's what was sort of available, what you could say. The other thing is, how do we think about the cases beyond sort of like the legal limitations and see the opportunity for the victims? The reparation measures can be an opportunity to change sort of the structural causes. To date, the Sapur Sarko case had 18 measures issued. The Achi women's case, in one case it's 12 and in the other one it's 19. The Sapur Sarko case, it's been 9 years since the sentence was issued, and some of the reparation measures have only been partially been implemented. But the more sort of like structural things like land has not been issued, for example. And we see military groups like opposing these decisions. We have upcoming elections next year to appoint a new general attorney, to appoint judges. These are also things that are important, I think, that we need to look at. How do we choose judges? How do we choose a general attorney? Because the current general attorney has dismantled all the cases, has moved the specialized prosecutors, and some of the judges, for example, in the Achi woman's case, why there's 2 trials? Because the judge did not take into account the testimony of the woman. She said there's not enough evidence that these men were paramilitaries, so she set them free. The women said they were paramilitaries. They identified them as paramilitaries. So even though the Sepulsarco case had made a great advancement in sort of demonstrating and showing how the women's testimonies can be like sort of the central evidence in these cases more than 30 years after sexual violence had happened, it hasn't sort of transmitted, or it hasn't been like been a part of all of the cases. We need judges that learn from all these other cases, that take the jurisprudence from these other cases to be incorporated. So we need good judges. We need judges that understand this sort of thing and that value the testimony of women and that will not question it when it comes to sexual violence.
I wanted to touch on a point that you made, Emily, in your intervention, and that is that even though these are colonial structures, we do not have to uphold them. We get to change the narrative, and we do not have to give in to the white supremacy and the fascism that is rampant, right? And there's a lot of ways that we can do that. Like I want to challenge you to think about how much professionalism is actually white supremacy. For instance, being on time. Yes, I love being on time. I like it when things start at a time. However, time is a social construct, and it's a colonial construct that was perpetuated by colonization. So there's that structure in and of itself, and we get to change those structures. Additionally, I wanted to talk about funding. I feel like as our opposition becomes ever more well-funded, we need to think about things in more creative ways. We need to think about how to do things and accomplish our tasks with very little funding or no funding. And the simplest way that I can put this is, what ways can we support each other without funding, right? You know, calling your friends does not require much money. A hug does not require much money. Most of the time, people just want to be heard. So being able to listen to somebody is in and of itself extremely community building. Make people soup. Just make people soup. Make people food. Food not bombs is a thing for a reason. Yeah.
Thank you, Paxton. No, good. And as someone who comes from a community that has its own standard time, Indian standard time is 15 minutes to an hour after something is said to start, so I appreciate your recognition. Priya, go ahead quickly, and then I'm going to want to open to the floor.
I just wanted to reflect on some of the points that have been made, and one aspect that's come through really strongly is the importance of the individuals who are involved, what we can do personally, and who are those who are appointed to these positions. And this is a theme, I think, that's come through yesterday and today as well. You know, who are those people that we're putting in place as decision makers? How can we do better in terms of making sure that the right people are selected and make it to these roles? And we are, for example, in the gender situation, in a very tricky position in many ways. Several weeks ago, 47 special procedure mandate holders issued a statement underlying the significance of gender as a concept, because that is necessary in this climate. in terms of gender backlash and regressive views around gender. Many of these UN roles, once you're in it for many years. It's 6-year term, and there are very little ways in which one can be removed. Brigitte, you mentioned certain judges, attorney generals. So I think one way to address this whole issue of structural discrimination being perpetuated by decision makers would be for us to think really hard about the ways in which individuals are put into these positions. And I'm on a panel now on structural discrimination. We all are. I've worked with colleagues who don't believe that structural discrimination is a concept. These are colleagues in the human rights world. They don't think that it's factually provable, or there is a view that they were not comfortable with the term and therefore they refuse to use it in certain contexts. So these are the sort of opposition that we have to overcome even within the field. And I think one of the difficulties we face is when these processes are put forward in terms of applying for these roles or being interviewed, there's also in this climate a certain level of masking that goes on. Individuals might say what is needed to be said so that they arrive at a role, but the agenda, whether it's anti-gender or whatever else the issue is, can be very different to the interest that we see as individuals aligned with human rights or human rights values. So that's an additional challenge. So I'll leave it at that, the importance of getting the right people to the roles.
Thank you, Priya. And I have 1,000 more questions for you guys. But in the interest of the topic of the conversation of not abusing my power, I'm going to open it up to the floor. And we'll take some questions from the floor if someone, yeah, we can take there, and then Amrita in the back, and then, and yes, Tamika as well. So there, and then 2 in the back.
Hello, thank you very much. It was all very, very interesting. My name is Maria. I'm an LLM candidate in international and transnational criminal law at the University of Amsterdam. So I have 3 questions, sorry. The first question is, we see many countries in the West, particularly European states, take initiatives to achieve justice for survivors. However, those cases are often handpicked by realpolitik in mind, which makes so some stories appear more valid than others, depending on the Western agenda. And at the same time, the very states championing justice are also complicit in creating the problems through histories of colonialism and ongoing practices. So my question is, how can we hold the very states that are leading these procedures accountable? My second question is, in some cases, the mass atrocity, particularly in a colonialist setting, is not state-led, but rather perpetrated by corporations. And we have a gap in international criminal law in holding them accountable. From a survivor-centered perspective, what could justice look like in those cases? So if you think about slavery, it only happened because we had banks that were giving out loans, insurance for the boats, and the loss of quote-unquote cargoes. In Palestine, we had a recent report from Albanese. And I think it makes it hard because also in the domestic jurisdiction, although it's not state-led, is also states are condoning or are complicit in it. And my last question is, in my view, there is a tendency to see crimes against LGBTQIA people as only quote-unquote homophobia or transphobia in a national setting and not an international framework, or even it's just a matter of policy. So it's not a problem of the US or a problem of is a problem of Trump. Trump is doing this instead of, it has already been going on for much longer than that. So in that case, how can we protect trans persons with such big gaps in international law? Thank you.
In the interest of time, I think we'll take Amrita, Tamika, and then we'll go back to the panel.
Yeah, is that right? So I wanted to touch upon this question of funding and capitalism and turn it on its head, because we know all of these intersecting systems. So we know that the money is there, it's being redirected to the military. We also know that these corporate entities are deeply responsible. So I know that we're at an international criminal law conference, but one of the questions that I've often struggled with is this, where do we invest these resources, and recognizing that when you take cases to corporate entities, you get money that you can then use to fund movement building and other things. implicit in that is a re-entrenching of a capitalist system, which is a tension I want to be very transparent about. But I do think as legal practitioners, when we look at all of the evidence that's now out there around crimes and the economy fueling those crimes, should we be thinking more about this strategic way of funding all of the movement building and the other work that we want to do, and recognizing that that corporate criminal responsibility is a huge lacuna that hasn't really been addressed?
Should we go back? I think we'll just take one more and then go back. So we'll see how much time.
Hi, everybody. My name is Tamika, and I am a human rights lawyer from South Africa. I just have a comment addressed to Emily. I just want to thank you for really addressing the elephant in the room. And I kind of just invite all of us to think a little bit about how we not just incorporate intersectionality. I think we've been throwing that term around a lot over the past few days. And so when we're talking about intersectionality, not just in relation to the work that we do and how we center survivors' voices, but also into how we do our work. And asking ourselves whether or not this space is representative enough, and whether or not we have enough practitioners from the Global South that are represented, and what can we do to ensure that they are represented. Because I think if we had to investigate that a little bit more closely, I think we would be coming up a little bit short. So I really want us to think about that a little bit more. Thank you.
Thank you.
Who wants to start? A couple of.
And you said, I'm not the problem with asking the hard questions here.
I just want to maybe say a few things about listening to some of the questions, and thinking about accountability and sort of what it means coming from a country that has been sort of colonized and been dominated by certain power groups that have who are responsible for the conflict and that we're not held accountable for, despite the fact that it's been more than 23 cases that have been brought to the legal system at the national level and about 12 at the international level, but they still hold power. So there's something there, and I think that they figured out a way to sort of make themselves invisible in terms of the responsibility that they had during the conflict. In the past, we had a UN commissioned commission for investigating corruption in Guatemala. It's called CICIG. And they started investigating corruption within the state and the links with businessmen and how they were fraudulently supporting and financing their campaigns. And there was like, they had a conference where they apologized for doing that because they were not reporting this. But this act is seen by them as such an embarrassment that they have promised themselves that this will never happen again. And they will not allow another international commission to come into the country and put them in such an embarrassment and to show what they have done to the country. They're the same group that also stopped the genocide case against dictator Efraín Ríos Montt. They are the ones who were able, that after 10 days that he was sentenced, were able to say, no, there's a mistake. And it was like a very procedural sort of error. And based on that, the trial had to be repeated. These are just examples to show the power and the dismantlement that they continue to this day, and the power that they continue to have and try to control the courts. And this is why I mentioned the courts before, because it is these groups that try to place the general attorney, that try to place the different courts, that will not allow for business people and for higher military people to be held accountable. So I do think that we do need to keep our eyes on these people. We do need to keep our eyes on where military expenses are being placed. We do need to speak out about that, make it evident to people, and speak out about it, and continue to shift the narrative into creating a more dignified, just system, I think.
I'll just speak briefly on the funding. My position, what I'm speaking from is as a grassroots organizer in trans liberation, specifically in the United States. And what I can say is that you be cautious of your funding. I worked for an organization where we were very selective with whose money we took, because we knew for a fact that many funders would not allow us to do direct action. And quite frankly, if I'm not able to feed a hungry trans woman at the end of the day, if I can't help somebody get their teeth fixed or help someone fix their car so that they can get to trial, what have you, what's the point? Like, liberation starts, there's Maslow's hierarchy where people need to eat, people need to survive. And if I can't fund that, there's no point in me taking your money. And I highly recommend that you go read a book called The Revolution Will Not Be Funded. It's really, really great. It also talks a lot about how the CIA funded things like the assassination of Fred Hampton through the Ford Foundation, fun fact. And Fred Hampton was the president, the director of the Panthers, the Black Panthers, not the Pink Panthers. Yeah. Right, so be very cautious. And that's why I recommend that you try to figure out how to do it without funding. Because if you cannot trust your funding, then you cannot trust the work that you do to a certain degree. Like, you never know when the rug will be pulled out from under you and that funding is a dollar bill, or that rug is a dollar bill, right? And that's why I say, like, there's so many ways that we can do movement work without money, or with very little money. Like, money is power, and therefore if you learn how to do things without that money, what you're doing is changing a power structure, which is difficult, and I don't have many answers on that, sorry, but I know that we can collectively figure that out eventually. I know that people power at times is greater than money, or it can be, I will say that. I had another point, I forgot it, but yeah. Also on the how to help trans people internationally with all of the impunity, that's a very good question. My thought is that we need to fight the impunity so that we can hold on, we need to fight the impunity so that we can fight the double standards, because truly my country is the problem. If right, if another country were acting the way that the United States is right now, the United States would be bombing it. We would have boots on the ground, exactly. And like, there's so many layers to that, right? There's the Security Council, there's funding. I knew for a fact that before Trump pulled funding for humanitarian aid, my thought was, wow, we fund a lot of really great things. What's going to happen when the United States no longer wants to fund those things? And it happened, and it was very scary. It's still very scary. People are dying because of that. Just goes back to show, like, be careful where you get your funding. But yeah, I'm not sure. We need to have community, because when justice fails, community won't. We need to support each other where there are no other supports, because people, what fascism does is it seeks to erase what makes us human. So be human in the face of it and defy it.
So a few thoughts on the very interesting questions that have been asked. The first question about the sort of duality, states that provide funding, but at the same time, their own human rights situation on the ground is what needs to be worked on as well. I would say in those situations, and given the funding crisis that we are facing, is to use the mechanisms that are available, in the sense that states that are mistreating their own citizens, there are UN entities that that are tasked with highlighting these issues. So to continually use those mechanisms as a means to uncover and hold those states to account. I'm always fascinated by certain countries who fund work on gender at an international level, but at a ground level within their countries, there are huge issues with structural discrimination, for example, against indigenous people, indigenous women in particular. But this is the duality that we function with in this field. And as Paxton said, it's to be assessed on a case-by-case basis. And until we find a better funding model, this is the landscape, and each entity that you work for, each organization has a different framework, different funders. But what I would say as an overall answer to your question is use the relevant mechanisms. So at ground levels, there are UN entities or UN bodies that are able to work in pursuing accountability for those sort of violations. But on the other hand, the funding is given for international work per se. So it really is one that has to be nuanced on the basis of your own situation. It's obviously not a straightforward answer. And similarly, on the question about financial crimes and also the issue of corporate criminal responsibility. I mean, interestingly, when we were talking earlier about the structure of international criminal law and the crimes that have been included and the crimes that haven't been included, in early discussions about what might constitute core crimes, there were discussions around these sort of crimes committed by corporations or crimes involving mercenaries, which, as we know, is a huge issue in certain parts of the world. So here we see through this question that was asked, the price that we pay 50 years later when we don't properly account for relevant violations and create a hierarchy of crimes that serve certain states and not others. So again, I don't have a straightforward answer, but I think we can start the discussion about which crimes should be included, how can we decolonize and remove this sort of discrimination from core crimes. And we can get there. We see this discussion, happening with gender apartheid, the work that Akila is doing. There is movement along crimes to do with the environment. So it's a question of us, working together, prioritizing and reflecting on where we would like to see international criminal law as a practice and framework go. So I'm happy that I'm able to say something positive in a way. But let me then just conclude in response to I guess it was more a comment on the role of intersectionality. And you're entirely right that, it's used in many different ways, and it's been, it's sort of the new term now in the field. You're in this area. First you have gender, then you have new victim groups, and there's a focus on that. And now gender analysis, hopefully we have come to see that it addresses some issues, but not all. So intersectionality has a role to play. We've talked about matrix of oppression, identity, intersecting discrimination. But for me, at the core of the work that we do, I see intersectionality as an approach that is really grounded in humility and curiosity. That is the lens to which I would like to do the work of international criminal law or human rights law. And this comes back to some of the discussions we had earlier today, and I think it was the human rights activist from Israel. I can't remember her name. I think it was Yuli. She said that human rights is obviously a legal framework. It is a way of enforcing rights, but it's also a value. It's something larger than that. It brings people together. It's a belief in a common understanding of the value of each other. And I see intersectionality through that lens as well. It is a concept, it's a sense that asks us to be curious and to be reflective and to be humble, because that's the only way you're going to understand what the survivor in front of you has experienced and is interested in sharing with you. And it's very significant to not have that top-down approach, which is what Emily was also talking about. So I see the idea as one that, you know, is value-based, and for me, humility and curiosity is at the core of it. And as Paxton said, you know, it's listen to us. And that would be a core feature of an intersectional analysis, I would say. It, of course, feeds into your view that it's everything and, you know, it has the ability to take on a lot. But if we take a value-based approach around the work that we do, this would be an aspect worth reflecting upon. I think just general curiosity around these issues. Thank you.
Emily, last words. Maybe I'll grab that one from you. Thank you.
So thank you. I'll be brief because we don't have much time, but thank you for your questions. I think you're studying right now. So I think I would say, what a weird time to study international law, you know, nowadays. I mean, a lot of us in the room, I mean, those I know, we were in your shoes 25 years ago, 20 years ago, and we were sold international law as, you know, will change the world. We were sold like, work at the UN is your dream job. And I think things have changed a lot. No, things have changed a lot nowadays, because your questions are showing us the limitation of international law, international human rights law. And 2 years ago, we were celebrating UDHR 75. And a lot of us were always brought in rooms to reflect, so what do you think of UDHR 75? And a lot of us had to reflect, you know, what we see is happening right now in Palestine is just showing us that international law is not working. As you said, it's working for some, but it's not working for everyone. And I think as you are students, and as many of you are the new generation and the Gen Z, you know, you have the power to build a new reality. And you also have the power to build a new way we understand international law. So don't restrict yourself to what you are being taught in the global north. And I hope that many of you are going to go back home and just don't dream to end up at the ICC or, you know, end up at the UN. Or I know it's a dream job because that's what we have been sold all the time. But go back home, because this is where people need you the most, you know? And for all the questions that people ask about, how can we hold people into account? How can we hold businesses into account? It's difficult. Like, the reality is that it's difficult and it's almost impossible because of the way international law has been built. Like, there's a binding treaty on business and human rights. It's more than 10 years negotiations. Every time we go to the negotiations, every time we come back defeated, you know? So it's take a long time also to negotiate a treaty. So learn what you need to learn, but go back home where people need you the most and build a new reality. Like we had Gen Z in Indonesia, in the Philippines, in Nepal, in the streets to protest against corruption. We have now people in the street in Morocco to protest again, you know, the way that hospitals are dealing with women in the hospital, also talking about inequalities. We have people in Madagascar also protesting against corruption. So it's really all about people power. And as much as we ask questions about where does the funding should go, how do we accept funding, in the end of the day, it's all about the values that you hold as organizations when you're working with people on the ground. If your donor doesn't allow you to stand in solidarity with Palestine, would you take the money? If your donor does not allow you to stand in solidarity with the LGBT community, will you take the money? In the end of the day, the question that you're asking us is a question that you should ask yourself, because it's all about you and your values and where you stand as a human rights activist and as a human rights lawyer, as a human rights defender. And I just want to end with the 40s of solidarity. So Akila and I, we were in a symposium of human rights leaders where we were trying to build the blueprint for solidarity, because we were asking ourselves, what comes at the stake of us being able to challenge corporations, challenge authoritarian governments? What comes at the stake of us being a strong movement? And it always comes to the point of, are we truly standing in solidarity with one another? So here, like, I just want to give you a framework. You can apply it, you may not apply it, but that framework works for us on the ground. We call it the 3 Ds of solidarity, but I added a 4D in my work. And so the first D, it's deference. It's really important that when you're standing in solidarity with people, you defer the power to those on the front lines. You're not guiding people what to do. And I say that a lot to our INGO friends, You need to defer the power to those on the front lines. The second D is differences. You need to accept and embrace differences. You know, it's not because someone is different to you that you're not going to stand in solidarity with them. Human rights are interrelated, right? There's no one human right more important than the other. So your issue is not important than the other person's issue. So you really need to be able to embrace differences. Disagreement. The third D is disagreement. You need to be able to agree to disagree. And again, I'm saying that to our INGO friends. How many times have you stopped solidarity because the local groups doesn't want to agree with you? How many times have you stopped the funding or the grant or the sub-grant to your partners on the ground because the local group disagreed with you? You did not stand in solidarity with them when you did that. So it's really important to agree to disagree. And the fourth D is decolonial. Everything that you do when you stand in solidarity, please apply a decolonial mindset and always ask your question. Am I holding the power? Am I deferring the power? Am I embracing differences? And am I okay to disagree with my local partners on the ground? Thank you.
Thank you. Thank you so much, everyone, for sitting in challenge with us, I think, during this conversation. And hopefully we take some of this forward into the next sessions and as we go forward back into our own spaces. And really just a second to say thank you to our panelists for really helping us navigate a difficult conversation with maybe not answers, but really helping us provoke further thinking on what we do. So thank you. Thank you all. I think there's a coffee break now that you can go to and continue the conversation.